I almost knocked myself out. Jesus Lord. Shit, motherfucker. Ugh. Okay. What do I sound like now? The fuck? Is it bad? Still. Be honest. Okay, great. Jesus Lord God. God. It's so crazy. I hate that. Much better? Great. Great. I don't know why it does that shit. I don't know. I'm going to share the audio on this tab. Let's see what it does. I don't know. Hooray! That's Scott's truck. Car. Hey, Hope for Me Farm. I know who you are. Good to see you too. Scott's car is not loud enough, is it? Is it? It's awful. It's so loud. Okay, so we're gonna go over this. This is not Dolly Vision. Good Lord in heaven, help us. So, who he is a blogger from Massachusetts. He's been on the Glarers. He's been around a long time. And he has been, yes, Gavel, it is definitely your fault. For sure. Why did you go watch him? And now he's arrested? Damn you, Gavel. So he's been arrested for witness intimidation and conspiracy and all the things. You watched him on the Glera. Okay. So, just so we can all, yeah, he was live last night. He just posted 15 hours ago on Twitter. And he was live last night. So it's crazy that this happened. But I'm sure he was expecting it because this is, this is what he does. He's not scared. Okay. I'm sure he expected this because of the things that he was doing. He was not shy to do any of the things. Of course, now Scott needs to call me. Hold on, please. Okay, I'm back. Isn't he always in trouble? No, he's not always in trouble. They got him. I mean, okay. So we can see if you guys want to see what happened. This is on, let's see here. Hold on. I'll show y'all. Fucked up. Hold on. Here he is. Do you have anything to say to the charges? What do you have to say? Do you have anything to say to the charges? He says, I hope they find that Ford Edge. There he is.
What do you have to say?
He doesn't give a shit. Do you hear me? He don't care. He does not care. So he'll be fine. This is what he does. As far as him being intimidated by them, he's not. As he said many times, he's just not. He's not intimidated by them. He sees them as, criminals with a badge. And he just goes and he says what he has to say, and that's the end of that. He doesn't care. If somebody wants to drop his link in the chat, that would be great. But I know there's a lot of people who may not know what he's fighting for and why he's doing what he's doing. No, he's definitely not intimidated. He could give a shit less. I'm sure it's aggravating him, but he was arrested on witness intimidation charges connected with Karen Reed's case. So he's been fighting for Karen Reed's case since the beginning. Yep, they got him, Cherry. I mean, they put a special prosecutor on it. Can you imagine? They put a special prosecutor on it. Irish Rebel? No. That's why it says not Dolly Vision. Not Dolly Vision. I know that he has Turtle Island and all of that, whatever. I don't know. But no, this is about an actual court case, an actual travesty that's happening right now. So, not Dolly. No, not at all. TurtleBoy has been running a blog for absolutely ever. He's on YouTube as well. He's on Twitter. He's on all the things. He is extremely outspoken. Masshole, if you want to call it that. No, it's fine, Irish. So, there's no volume. You guys can't hear me. No, I'm right up here. Thanks, Andy. He's doing quote at 2 o'clock. Is this better? Okay. Yes, he is very funny, but some people hate him. Some people compare him to a JLR. Some people compare him to a tragedy pimp. He is none of those things. He is doing what he's always done, right? He just used to write the blog forever. He's written 130 some odd blogs just on the Karen Reed case alone. So I will show you guys his, it's called TurtleBoy Sports. Let me see, Karen Reed, how many he's written now. There's so many, it's insane. I don't even know. He's somebody who, I'll give you just a little insight into who he is. TurtleBoy wrote about my ex's best friend's daughter that I've known since she was 2 years old. She grew up and she got on drugs and she got into some crime stuff. And he wrote about her. He put her face out there. He put all the things out there. He didn't give a shit. He's somebody who goes after people that he feels like are garbage. And he doesn't care. So Dietz and I have talked about it off and on for the past couple of months, this case. And then Glairer heard about it from us. And then Glairer had TurtleBoy on his channel. And they did a great live stream. But even so, there are people who have no idea what this is and why this case is important. You know, all the people he puts out there too, right? It's embarrassing. It's like, oh my God, Aiden, please don't put my friends out there. That kind of sucks. But that's what he does. He puts them out. He's a trusted source. He is. and he gives zero fucks to anything at all. You're not sure about the case he is covering. You've been on a deep dive. Okay, so what we're going to do is we are going to watch the Karen Read hearings, if you guys are okay with doing that. I've lock your. You do not want him. He's the type of guy. So if you think people like JLR and those guys are like trolls, no. He will dig up the most on your ass. He really will. It's crazy town. It's crazy. He calls out corruption. He absolutely does. He calls it out and he does not care. Mary, you must know who TurtleBoy is, I'm sure. But yeah. So we're going to watch the Karen Read case. He backs the blue, but no, yeah. So that's the thing. People are mad because he's going against, and that's the big thing. Oh, hell yeah. He was arrested this morning, Murray, for conspiracy and witness intimidation. I love you too, Ange. So let me just break it all down really quickly so that we all know what we're doing here. Karen Read was dating. Hold on. Karen Read. Yeah, arrested. Murray. He's in the jail, Murray. He's in the jail. Okay. Karen Read's ex is named John O'Keefe. He's a Boston cop, right? Skilo. And they went out with some other cops. Yeah, I was muted for a second. I mute if I have to talk to anybody in the house. I don't want all my business all over the internet. So she was drinking. He was drinking. The other cops were drinking. Their wives were all the people were drinking. Okay. And they decided to go to some bars. So they went to the bars and somebody invited him back to one of the other cops' houses. He ends up going and they go together, but she didn't want to go in. She felt uncomfortable. She didn't really know these people. She was kind of like, yeah, no, I don't want to. And she leaves. He stays. She gets up in the middle of the night. He's not home. So she's like, where the fuck is he? And ends up, he's dead in the front yard of where she left him, right? She's dead. He's dead in the front yard. So she's freaking out. There's all the things. Headed to the market. So she's now charged with his murder. They're alleging she backed into him, which is just, what are you talking about? So TurtleBoy got very, very, very involved in all of this stuff. And Sleuthy Goosey, she's unbelievable. If you go to Twitter, you will find her. And she's literally got every single fucking thing. Hey, Quinny. So she has the who's who. She has the witnesses. She has the documents. She has the discovery. She's got all the things. Okay. And I was not going to push and cover this. She does have a good girl. So TurtleBoy's covering it. It's like his thing, right? But for him to get arrested, I mean, I'm sure he'll be right back out. He'll have court today. He'll be out. But it's something that I've been wanting to cover. I was talking about it during one of the cases that I was doing. So we're going to go over the court cases. I'm going to put them on for you. But this case has so much corruption, and all the people are fucking cops. What do you do with that? So for him to go against cops has been not good. You know, they're pissed. They don't want that. You'll see in these videos that I'm going to show you that the cops are standing in the courtroom like intimidating. Boston police have a brotherhood like no other. And that is so true. If you're not from there and you're thinking, oh yeah, all police are like that, Boston's like something I've never seen. They will protect each other to the death. And it's true. Sleuthy's Karen. What do you mean, Sleuthy's Karen? What does that mean? Sleuthy is the sleuthiest. That's very true. Conspiracy and witness intimidation is what he was arrested for. So I don't know what Sleuthy's Karen means. The fuck does that mean, Glara? So what I wanted to do is go through the case and show you guys why he's so passionate about this and going up against cops and now risked his own freedom. He knew what he was getting into when he's going after like elected officials and crashing their events. And he did. He's, oh, her Karen Ricci. Yeah, I have it right here. Thank you. Yeah, prepared to be angry because it sucks. I want all the just for the accent. I know they're so good. Yeah. It's absolutely intimidation, but it's not intimidation when they do it, but it's definitely intimidation when him alone goes and crashes a party that he's not supposed to be at or follows people when they're getting out of court. You know, it's insane. It's insane. Absolutely, Queen. Oh, he's trying not to be a boomer. They arrested him at his children's bus stop. They're saying, is it live right now, TikTok? He's going after, come on. No, he isn't going after minor children. There's no minor child, Laura. There's no minor child. There's a couple of punks who he does, you know, talk a little bit of shit on. But he's also gone after elected officials in their face. He's going after the cops. That's who he's going after. Hold on. Is he in court yet? No, he's not in court yet, is he? Court. Just in custody. When is he going to be in court? I'd love to know. Stoughton District Court, Massachusetts State Police. It wasn't clear what the charges were. Yes, it is clear. He's being said, seen, let in. Okay. There you go. As of Tuesday. As of Tuesday, he has posted 179 articles alleging that the investigation into O'Keefe's death involved a cover-up involving state police who were investigating the case. What are my what? I can hear my daughter out there. I'm trying to hear what she's saying, but I can't hear her. Kearney has pursued other causes on his websites, writing repeatedly in his characteristically caustic style about former U.S. Attorney for Mass and Suffolk District Attorney Rachel Rollins, longtime local activist Monica Cannon Grant, as well as others, churning up information, usually through social media, on less public figures for alleged wrongdoing. His current website describes Tim as a teacher turned blogger battling big tech censorship, threats, and political correctness. Hold on, please. I don't like anybody in my house. Do you care? Does anybody give a fuck? Because I don't. I want to fucking punch them in their face. All right. I'm going to start playing this. Now, you have to let me know when I mute myself. Can you hear him or no? What is Laura saying? Again, Laura. Laura? Laura saying something. I'm sure she has a... Hey, Ashley. Oh, yes, he is. I haven't done my full research. I've been following this case since week 1. When did you start following it? I started following it week 1. Me and Dietz have been following it literally together since the very first day. I know exactly what he's doing. I know what he's doing. I know why he's doing it. He's explained it over and over again. He has tactics that he uses. And believe me, the kid in the pizza shop, he wants to come out and beat TurtleBoy's ass. He isn't intimidated at all by TurtleBoy. He doesn't give a shit about TurtleBoy. No, not you. Not you. No. No, he doesn't care about TurtleBoy. In the least bit, he doesn't care. He just came out and told him to go fuck himself on video. So. Oh, Dietz is around. I messaged her that he got arrested this morning. So I know what I understand what he's doing. Like, so somebody will say, well, Dolly Vision, or who was it? Somebody went and harassed Hunter. Well, if Hunter came out and told him to go fuck himself, then I'll be like, well, he's not very scared, is he? He's Jim Terry from Boston. If you don't get the hell, he's definitely not Jim Terry from Boston. I've been following this guy for 25 years or however fucking long he's had his blog. At least, God, he's had his blog forever. TurtleBoy Sports. All right, let me know when I flip this if you can hear the video and not me. Hold on. Do you believe the medical examiner and the CART team are in on this? No. I believe that the cops absolutely did this. I think something happened in the house. He had bites all over his arms, scratches, a huge gash on the back of his head. So the medical examiner can't say, well, this person did it. They can't say that, right? They just know something happened to the guy and he's gone. He's not here anymore. The police in Boston and Massachusetts have a lot of pull. And one of these families has a ton of fucking pull. You're going to tell me that backing up into him bruised his knuckles, put a huge gash in the back of his head, put bite marks all over his arms. No, none of that happened. It did not happen. The medical examiner's job is to determine, it's not to be the detective in the case. You know, you can't see heels for some reason. I don't know. Yeah, I believe they probably got in a fight and the dog protected its owner, as it should, right? As it should. But you've got these people who are all connected to each other, right? Absolutely, Quinny. Something happened in the house. For sure. Yep. Red Charm, he is a very smart guy. And people may not like him. And that's fine too. I mean, you don't have to. I didn't particularly appreciate him when he went after my really good friend's daughter, who's now dead. I didn't appreciate it. But you have to be from there and know who these people are to really understand all of this situation. It's screwed up. It's a very screwed up situation. And could something have happened and they're just like, fucking don't say nothing. You just don't say shit. Put them back out there, leave them there, and enough is enough. Just leave it there. Sure. Absolutely. So, very briefly, very brief. And the dog's rehomed and Coppets replaced and they sold their house and he never even come out of his own house to investigate or see what the fuck happened to his friend who's dead on his lawn. Please. No. All right. So let's just very quickly go down the timeline so everybody knows what we're talking about. 9 p.m. Karen Reed meets her boyfriend, the victim, at C.F. McCarthy's in Canton. He had already been there. She, at 9:15, has a drink. She receives a shot glass at 9:20. Another shot glass at 9:30. 9:57, she picks up a tall cylinder glass. Brian Albert and Nicole Albert arrive at the bar at 10. Karen receives another shot glass at 10:22 and another at 10:29. She pours them both into her cylinder glass. Those two, Karen and the victim, leave together. She's holding her last drink in her right hand as they exit the door. Julie Albert texts the victim because they're inviting them. I think they're going to the next bar at this point right now. Your husband's working at Canton this week. Nicole Albert leaves the Waterfall Bar and is met by her sister, Jennifer McCabe. Ryan Nagel receives a text from Julie Nagel requesting that he get picked up at her house, Brian Albert's house. That's where they all end up, is at Brian Albert's house. That's where everybody is asked to go. She doesn't really know them that well. Karen Reed. She doesn't know them that well. So she's kind of just like, I don't really know, whatever. So, John O'Keefe texts Jennifer McCabe. Where to? This is at 12:15 a.m. Jennifer calls him and he answers. And then there's 44 seconds where they have a conversation. This was deleted from Jennifer's phone. Okay? Why would she delete that call? Nobody thinks that's weird? Okay. A large black SUV, consistent with Karen Reed's Lexus, travels on Washington Street and continues towards, I think it's the Temple Church. Yeah, Temple Beth Abram. Then Ryan Nagel arrives at 12:15 a.m. So she drops him off. She's leaving, right? Ryan arrives. If there's a dead guy on the lawn, would somebody have seen him by then? Allegedly, maybe. I don't know. Caitlin at 12:15 is picked up by her boyfriend. You can see on video surveillance Karen's truck. Jennifer McCabe arrives at 12:18 a.m. Jennifer receives a call from the victim. Oh, wait. No. She's driving there. He's not dead yet. I'm sorry. He's not dead yet. They're driving there. You can see her truck going past. Jennifer McCabe receives a call from John, also deleted from her phone. So that's 2 deleted from her phone. Why? Jennifer McCabe texts John here, question mark, at 12:27 a.m. 12:29 a.m., Jennifer calls John. John is the dead person. He answered. That's also deleted from her phone. Would you come on with this bullshit here? Bullshit. Okay? 12:30 a.m., Colin Albert returns to his parents' residence a few houses down from where the victim lives. Jennifer McCabe texts John and says, pull him behind me. That's at 12:31. At 12:40, she texts him, hello. 12:41. Karen Reed is at John's house. She's already gone from where she left him. Leaves him a voicemail, and you can hear the garage door closing and the house door closing when she goes inside. 12:41 a.m. Jennifer McCabe calls him. 12:41 in 10 seconds. 12:41 in 59 seconds. She calls him again. These are all deleted. Just understand they're all fucking deleted. 12:42 a.m. She texts the victim, where are you? 12:43 a.m. She calls him and it's unanswered. 12:45 a.m. She texts him, hello. 12:46, 12:47. Both of those are deleted. Okay. All guests leave the Alberts' residence by 1 a.m. Okay? So he arrives there at 12:24 a.m. 12:24. By 1 a.m., allegedly, everybody leaves. Okay? If they left, they don't see a dead person on the lawn. There's no dead person on the lawn. Like a whole large man dead on the lawn from his girlfriend backing into him. None of that happened. Okay. Okay. None of that even makes sense. So there was a guy, Brian Lucky, they call him Lucky, at 12:15 a.m. He arrives to go get his dump truck and begin plowing because it's going to snow. He arrives between 2:30 and 3 a.m. and sees a Ford Edge, which is why TurtleBoy just said that when he was being arrested. I hope they find that Ford Edge parked in front of 34 Fairview Road. Okay. Let's see. There's a bunch of calls. There's a bunch of deleted. Jennifer might as well have just fucking wiped her phone clean. She might as well have just wiped the whole phone clean at this point. Which, it's ridiculous. Karen ends up waking up. She's calling Jennifer McCabe. She's calling other people. She's looking for him. She doesn't know where he is. She leaves her house around 5 a.m. She's calling John. He's not answering the phone. What time do they get there? She leaves her residence at 5:39 a.m. What time does she get there? Jennifer McCabe arrives at 6 a.m. at 34 Fairview. So everybody ends up getting there. And there's a call, a text search, 6:23 a.m. How long does it take to die in the cold? Right? That she ends up trying to delete. Which, why are you Googling that? She Googled it a couple of times to make it seem like she deleted it once and it was all misspelled and weird. Like 6:23 a.m. How long does it take to digest food? She texted. She searched on the internet. You're out looking for your friend. He's probably deceased, right? You know at this point he's deceased. And you're asking how long does it take to digest food, and then how long to die in the cold, and then you try to delete those searches, but that doesn't work either because the internet shits forever, friends. And all of this is happening on the Alberts' lawn, and he doesn't even come out to check on his friend. Yeah, there was at 2:27 a.m. She does the first search that was deleted, okay? Haas Long to die in cold. Okay, that's at 2:27 a.m. That's the first time that she searches for that. Haas Long to die in the cold. Okay, 2:27 a.m. At 2:26 a.m., Jennifer deletes 2 screenshots that she has. What was Jennifer doing? Jennifer's gonna sink this whole case, right? So she does that first. Then at 6:23, after she already knows he's dead, she does it again. And the theory is that she did it again to try and cover up for like the first time, right? She did text him a couple of times with just hey, where she deletes it. So we're going to play the court stuff so that you guys can hear it in their own voices. But I think it's really strange, and I can't imagine why anybody who has nothing to hide is deleting everything, but also is doing internet searches for how long does it take to digest food. The fuck? What are you doing? What are you doing? And she, like, Jennifer McCabe is so far all up in this. It's her name constantly. Constantly. Karen was angry at John because she thought it. Nah, maybe. She might have been. She might have been. Now, I'm going to mute myself. Let me know if you can hear the court thing. Hold on.
From Worksman Jackson and Quinn on behalf of Karen Reed.
Good afternoon, Mr. Jackson. Good afternoon, Ms. Little. Good afternoon, Ms. Reed. Okay, so we're here for the Rule 17 motions. Who's going to argue those?
So, Your Honor, there are 2 motions before the court that we'd like to be heard on. One is the motion to renew our motions to compel, which we'd like to be heard on first, if the court pleases. Okay. And I would be arguing that motion. With regard to the Rule 17 motion for the animal control records, my colleague, Mr. Jackson, would be arguing that second, if the court pleases.
Okay. All right, I'll hear you.
Thank you, Your Honor. May it please the court, we are seeking immediate access to John O'Keefe's clothing, to all evidence seized from my client's vehicle, to tissue and other samples from John O'Keefe's autopsy, and to the original Canton Library video, which we still do not have. We are asking this court specifically to set a hard deadline for access to this mandatory discovery and evidence. Your Honor, at the outset, it is important for me to emphasize why a deadline needs to be set. It's important to emphasize why time is of the essence for our access to this evidence. It's been 15 months since my client was arrested and falsely charged with killing John O'Keefe. Prior to 15 months ago, my client was employed in 2 prestigious positions. Prior to 15 months ago, she had a robust health insurance plan that covered her numerous serious medical conditions. But 15 months ago, she lost everything. 15 months ago, these false allegations began to destroy her life, and for the last 15 months, she has been fighting for her life. 15 months after her arrest, she has no income. She does not come from a wealthy family. Her father was a respected and now retired educator. Her family is very squarely middle class. But given that Karen Reed is now fighting for her life, whatever money that they've saved is all going to her defense in this case. She's hired private counsel from 2 coasts. She's hired multiple experts at considerable costs. And when I say considerable, I mean tens and tens of thousands of dollars. And the meter is running with each passing court date. She can't afford to scrimp on her defense because her life is at stake. In the 11th months that this case has been pending in this court, we have continually asked for access to the same basic mandatory discovery evidence. We've been prohibited from inspecting that evidence. In February of 2022, the police seized John O'Keefe's clothing. It's now May of 2023. We haven't seen it, we haven't inspected it, we haven't been able to test it. In February of 22, the police seized pieces of taillight from my client's vehicle, pieces that they claim to have found at the residence where John O'Keefe died, despite the fact that multiple searches initially turned up nothing. Pieces of the taillight were only found after Trooper Michael Proctor, conflicted Michael Proctor, had seized my client's vehicle and had it in his possession for well over an hour. That evidence needs to be put to the test, and it needs to be put to the test now. We have been prohibited from testing it, from inspecting it, from even seeing it. There were tissues and other samples from the autopsy of John O'Keefe to which we've been denied access. We believe that when those samples are tested, the results will be exculpatory, likely case ending. But 15 months after she was arrested and 11 months after she was arraigned in this court, that evidence remains hidden from the defense. The police have maintained exclusive control over the event data recorder and the Lexus infotainment system from my client's vehicle. We have seen neither, and this is simply unacceptable. Prohibiting the defense from inspecting this evidence is infringing on my client's constitutional right to a speedy trial, and it's infringing on her right to due process. It's almost 3 months ago that we last appeared before you, Your Honor. We requested access to these items, and yet again, the response from the Commonwealth was that they would be tested soon. The prosecutor had represented within 30 to 60 days. That's on record. It's now close to 90 days. We've made zero progress. This court did order that the Commonwealth request expedited testing, but that...
Do y'all see all the cops back there? Do you see them all? And this is a regular thing that they've had. All these cops. You should see them all. There's TurtleBoy right there. There he is. If y'all can see him. These cops are all lined up. It's intimidating as shit. It really is. And now, did Karen and John have some issues? Sure, yeah. I mean, what couple doesn't argue and fight and whatever the fuck? But if anything, she may have backed into him, not known, and that's if anything. And I don't even believe that happened. I don't even believe that happened, right? So yeah, intimidation. That's exactly what it is. Yeah, is he that dangerous? Well, they're there to intimidate her and him, right? Because he's the one speaking up. Prior to him getting involved and learning about the case, the courtroom was empty. It was empty outside. It was empty, whatever. It was not a big deal. It wasn't this. And he started digging, and people really started freaking out because he's got a big ass mouth and he wasn't going to let it go, and he hasn't. And now he's arrested. So
that order has yielded nothing. I asked the court to set deadlines then, which the court was not inclined to do. 3 months later, it is crystal clear that deadlines need to be set. Without a deadline, we have no assurances that this case will not drag on who knows how long into the future. With each passing day, my client, who not only is presumed to be innocent, but is factually innocent, remains jobless, with inadequate health insurance, and with each passing day, her savings and her family's savings continue to be depleted. There is no time to wait. There is no time to waste. It is time for excuses to end. As we noted in our motion, the prosecution and the crime lab move very quickly when they want to. In other cases pending before this very court, the very same investigators secured DNA testing within 2 weeks of opening their investigation before anybody was charged. Contrast that with our case, where here we are 15 months later, no such testing has even started. Regarding the Canton Library video, this court should know we still do not have relevant time periods. From the Commonwealth's evidence, we know that my client drove by the Canton Library at 12:16 a.m. on January 29th because that was recorded. There is video of her driving by at that time, heading to 34 Fairview, which is where John O'Keefe died, with her taillight intact. We know that my client arrived back at John O'Keefe's residence at 1 Meadows Ave in Canton at 12:41 a.m. because the Commonwealth produced a voicemail that she left for John, where you can hear the garage door closing.
no, this video here is not live. This is a catch up of all of it together so that everybody is aware of what's going on and why that guy in the green right there is arrested. I don't know if they're going to have it. They may have it on Channel 5 ABC. I'm not 100% sure, but since he's a pseudo celebrity there, they might. They might. I've heard it's supposed to be like around 1 o'clock. I don't know if that's necessarily true. Let me see if I can find anything on it really quickly. For his arraignment. He doesn't give a shit. He's just like, yeah, whatever. Go find the Ford Edge. Get out of here. So let's see here. There's comments up here. TurtleBoy has done more honest and factual reporting than all of Boston media combined. Yeah. Let's see. So he has been charged with witness, juror, police, court official, intimidation, 1, 2, 3, 4, 5, 6, and conspiracy. So, let's see. Let's see. Defense Diaries is covering it, so I am following them. They're following to see what's going to happen with him. Oh, hold on. Oh, it's live. Hold on. It's so low though. Shit. Let me see if I can bring it over here. Wait a minute. So low.
Presented by the Commonwealth's argument, the defendant has shown up at sports games, attended or that were being engaged in by children of witnesses, and has made scenes there using loudspeakers, etc. We're asking that he be precluded or prohibited from attending those sports games, school or otherwise, to harass witnesses. That there be no mentioning by names or other forms of identification of the witnesses on his blogs, Twitter, YouTube, etc. When I say witnesses, I'm also talking about the victims in this case, Your Honor. The victims in this case all being witnesses in another matter that the Commonwealth will address. Certainly, this would not preclude the defendant from talking about other cases, but not with respect to discussing the witnesses and their family members, etc. We're asking that he have a stay-away order from D&E Pizza, and that he be precluded from encouraging his blog followers from harassing and intimidating that business, that he not contact witnesses' family members, schools, sports teams, coaches, etc. He has done that in the past, Your Honor. That he not photograph or video witnesses at home or work, and that also goes to taping, Judge. And he not contact the place of work of the witnesses or victims. And I have a large number of facts I would like to make the court aware of. I apologize for the time it's going to take. There are 9 complaints before Your Honor. Some of these facts apply to all. If I could just read that section to the court once or recite those facts and then deal with them individually. Thank you, Judge. Your Honor, on the morning of January 20th, 2022, a gentleman by the name of John O'Keefe was found unresponsive on the front lawn of 34 Fairview Drive in Canton, Massachusetts. He was transported to Good Samaritan Hospital where he was pronounced deceased. The Office of the Chief Medical Examiner determined the cause of death to be blunt force to the head and hypothermia. Evidence was presented to the Norfolk County Grand Jury that indicated the on the night of January 28th, 2022, Reed and O'Keefe were at two Canton restaurants, C.F. McCarthy's and the Waterfall, where they met friends. And this is Karen Reed. After the Waterfall closed at shortly after midnight, Karen Reed and Mr. O'Keefe were invited to 34 Fairview Road in Canton. Witnesses stated Reed and O'Keefe did not enter 34 Fairview Road. The Norfolk grand jury indicted Karen Reed on second-degree murder, motor vehicle manslaughter while operating under the influence of alcohol, and leaving the scene of a motor vehicle crash causing death. The indictment alleges that Karen Reed struck O'Keefe.
Hold on. I got a better one where he's louder. Hold on.
Operating under the influence of alcohol and leaving the scene of a motor vehicle crash causing death. The indictment alleges that Karen Reed struck O'Keefe with a motor vehicle and left the scene, and the case is currently pending in Norfolk Superior Court as docket number 2282 CR 117. The lead investigator.
Just for the record, there are many people attending this hearing via Zoom. We're doing the best we can to keep them all muted. When you hear some random utteration like you just did, that's from someone who has not yet been muted. Yeah.
Thank you, Judge. The lead investigator for the investigation I've just described is Trooper Michael Proctor of Massachusetts State Police, assigned to the Norfolk State Police Detective Unit. Trooper Proctor testified before the grand jury and continues to conduct investigative work on the case. Michael Proctor is married to Elizabeth Proctor. Elizabeth is not a witness to the investigation, but a family member, as mentioned in Chapter 268, Section 13B of the General Laws. During the investigation into O'Keefe's death, witnesses were identified, interviewed, and testified before the grand jury. These civilian witnesses were present with O'Keefe and Karen Reed in the hours leading up to O'Keefe's death and his discovery on January 29, 2022. The witnesses include the following: Matthew McCabe, who was interviewed by investigators. Matthew was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death and observed an SUV believed to be that of Karen Reed's in the front of 34 Fairview Road and he testified at the grand jury. Jennifer McCabe was interviewed by investigators. Jennifer was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death, observed an SUV believed to be Reed's in front of 34 Fairview Road, and was with Reed when O'Keefe was found unresponsive, and testified at the grand jury. Brian Albert, interviewed by investigators. Brian was with O'Keefe and Reed at the Waterfall restaurant and the homeowner of 34 Fairview Road, and testified at the grand jury. Julie Albert, the wife of Christopher Albert, was interviewed by investigators. Julie was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death, and she testified at the grand jury. Chris Albert, husband of Julie, was first interviewed by investigators on February 10, 2022. Chris was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death and testified before the grand jury. Colin Albert was interviewed by investigators. He is the son of Chris and Julie Albert. And Juliana Nagel was interviewed by investigators. She was present at 34 Fairview Drive when people were arriving from the Waterfall restaurant and observed an SUV believed to be that of Karen Reed parked in front of 34 Fairview Drive. In an April 2023 motion filed by Reed's defense attorneys, defendant's motion for order pursuant to Mass Rule of Criminal Procedure 17 directed to Brian Albert, Verizon, and AT&T, alleged police misconduct and a conspiracy among civilian witnesses to frame Reed for the death of O'Keefe. The motion calls Brian Albert a suspect and Jennifer McCabe a conspirator who took calculated steps to purge her phone of this inculpatory evidence. A local blogger, the defendant, Aidan Kearney, had adopted the defense's claims. Kearney runs a series of websites and social media accounts under the name of TurtleBoy. The social media accounts include TV Daily News, X, formerly Twitter, with 33,800 followers as of last count. Aiden Kearney at Dr. TurtleBoy, X, formerly Twitter, with 44,800 followers. TurtleBoy, Facebook with 27,000 followers, and TurtleBoy Live on YouTube with 41,000 subscribers. He refers to his followers as Turtle Riders. Now, it should be noted that the defendant on many of his sites, his websites or blogs, if you will, has a pay section where he's requesting contributions from the public to support his work, if you will. And some indications are that it's been estimated on the internet that he has raised in excess of $5 million doing so. So this is apparently a business of his that he's engaged in. Beginning in April of 2023, Kearney began posting articles to his website and social media accounts where he adopts the defense allegations as true and makes personal attacks on civilian witnesses and members of their families and their friends. Kearney authors and publishes a blog on the website tvdailynews.com. The website has a series of articles entitled Canton Cover-Up. As of September 28, 2023, at least 164 articles have been posted to the website in this category regarding Karen Read, and there have been additional articles since that date. Kearney posts weekly videos to YouTube where he has discussed Karen Read and made statements regarding witnesses. Below are a small selection of the verbal statements made by Kearney in these videos that have been published to followers and are publicly available for viewing without being a subscriber or follower and have been archived by investigators. Episode 594, TurtleBoy returns to Canton. This is a video posted shortly after Kearney visited homes of witnesses. This is not my last trip to Canton. I will be back. I'll be back. Get used to this. These people think I'm fucking around. You haven't seen the last of me. Get used to it at the 119 mark. Episode 598, Breaking. Karen Read defense files motion to recuse. This guy, meaning Chris Albert, had his head on the swivel looking for Turtle Riders. I got bad news for you, Chris. I got really bad news for you. They are literally everywhere. You guys should just stop going out in public. It's only going to get worse from here. I know where you all were today. You were in Agawam, weren't you? You guys were at some sort of Little League thing in Agawam. Alberts, McCabe's, all you people were there. Just know that there will be no life as normal is over. Life as normal, you had normal for a while there, from January 29th to about April 2023. You guys literally got away with murder. States that at the 8-minute mark. While discussing the video of Chris Albert being confronted outside of a Canton restaurant, we, Kearney and his audience, are getting to them. Chris Albert, meaning Chris Albert and other witnesses. When you act this way, that's like a green light for me, time to hit the gas. I got pictures of you. You can't leave the fucking country, Turtle Riders. We're gonna find you. They're gonna find you. You can't hide anymore. Your private life is officially over. You leave your house, you're gonna have your picture taken, so you need to get used to the new normal, your new normal. Turtle Riders are gonna take pictures of you, and they're gonna send it to me. You're famous. We need to accelerate it. They, the woman who recorded the video of Chris Albert confrontation, are doing a fantastic job with this. Stated that at the 24-minute mark. On episode 604, entitled Colin Albert Drops Out of School, Brian Higgins Flipping, Is the End Near? I said from the beginning, I don't want this to go to trial. That is this defendant's words himself. I don't want this to go to trial, referencing the Karen Read case. On September 18, 2023, Kearney posted a blog entitled Canton Cover-Up, Part 142. Free Karen Read. Billboard goes up on Route 1 outside Gillette Stadium in Foxborough. More to follow on his website. The topic of the blog post was about a billboard that read, Free Karen Read, with a picture of Karen Read. Kearney praised the organizers of the billboard. In the post, Kearney wrote, Thank you to everyone who donated as well. Although millions of people know about the injustice that is happening in Norfolk County, I would bet that over half the population of Norfolk County has never heard of Karen Reed before. That will change because of this three-pronged billboard blitz. It's really time for people in Norfolk County to know about this story, because that is where the jury pool will be chosen from. Essentially, Judge, an admission that he's seeking to taint the jury pool in the case. On June 13th, 2023, Kearney broadcast a live YouTube video, episode 590, which is currently posted on his YouTube page. During the broadcast, Kearney displayed phone records of Jennifer McCabe from the day O'Keefe was killed. The records displayed names to the phone number, displayed names next to the phone number, which appeared to be the user of the other phone. These records had previously been an attachment to an unredacted defense motion filed in Commonwealth v. Reed. During the video broadcast, Kearney cold calls the phone numbers without names associated. In this process, he called the work cell phone of Trooper Proctor. Trooper Proctor stated the phone number that made the call was 413-262-69, and I'll omit the last two numbers, Judge. Kearney left the following voicemail. Hi, Trooper Proctor. This is award-winning journalist Aidan Kearney calling. I'm calling to talk to you. I do have some questions about you. I have a lot of questions, actually. For starters, why didn't you tell me, one, before doing the investigation, that you were good friends with the Albert family? Why did you, in the report, say that you were introduced to Chris Albert on February 10th, when you have known him for more than a decade prior to that? Why did you lie about that? About what time you towed Karen Reed's car? Why did you intentionally misspell the names of several key witnesses in your report? And you know, I'm just wondering about all those things, and maybe you and I can meet for coffee. Boy, do I have a lot of questions for you. Where were you inside Fairview Drive that night, or that morning rather? Why did you stay there for 4.5 hours, and what did you guys talk about and do? Why are you descending stairs with John O'Keefe's phone in your pocket? So give me a call back, man. We feel like you and I have a lot to talk, catching up to do. I talk about you a lot. I feel like I know you pretty well at this point. I know which year you graduated from the academy. I know you were out in West Brookfield for a while. I know some people that you know, so give me a call back when you get this. Now that I have your number, and everybody watching also has your phone number, which again is 781, and I'll omit the remainder of the number. So I'd like to know. She called you again. You called her at 12:49. We're going to get to that. So now I have your number. I'm going to plug you in, and we'll talk soon. Essentially, broadcasting the trooper's number to his turtle followers, if you will, seemingly with the intent to have them also harass him. As a result of the cell phone number being broadcasted, Trooper Proctor began to receive random and harassing text messages and voicemails. In the 12 hours following Kearney's calls, Trooper Proctor received approximately a dozen text messages, phone calls, and voicemails. The content of the calls and messages pertained to Trooper Proctor's alleged involvement in the conspiracy and called for his termination. Trooper Proctor had to change his work cell phone number to avoid the constant unwanted calls and messages. Michael Proctor is married to Elizabeth Proctor. Beginning in April 2023, Kearney wrote blog posts about Elizabeth Proctor. On May 9, 2023, Kearney authored a post about Elizabeth. A video was attached to the post. The video depicts a cell phone screen of an Apple iPhone. The user of the cell phone dials the cell phone number of Elizabeth, which is displayed on the screen. Kearney further writes, I can think of two people who deserve to lose their jobs over this alleged conspiracy about Karen Reed, though. Michael Proctor and Elizabeth Proctor. These two lowlifes think they're untouchable. They're nothing but bullies who terrorized people for years, but now they've met their match, meaning the defendant. In the post, Kearney states Elizabeth works as a human resource manager, and I'll omit the place of employment, and posts the main number for the company. The post then says, but you're probably not going to reach anyone that way, so feel free to leave a review on their wide open Facebook page or their Twitter account. On May 10th, 2023, Kearney broadcast a live YouTube video, episode 580, which is currently posted on his YouTube page. During broadcast, at the 1 minute, 6 second mark, Kearney talks about Elizabeth. He states he was going to call her. He repeated his cell phone on the broadcast, a cell phone number on the broadcast, as he was entering the number into a cell phone. Using the speakerphone option on a cell phone, Kearney broadcasted the phone call. The phone call went to voicemail. Elizabeth stated the call came from 413-262-69. I'll omit the last two. Kearney left the following message. Hi, Elizabeth. This is Aiden Kearney calling you back from TurtleBoy. We briefly spoke yesterday on the phone. I introduced myself to you and then you hung up on me. Or maybe that was a bad connection. But I just wanted to see how your day at work went today, if it went well. I noticed that your employer took down their social media pages within 5 minutes of the blog I published about your recent behavior. And I just wanted to see what is it awkward? Were you afraid to go in? Just tell me about your day and why, because that's the part I don't understand, is that you seem to be okay with calling other people's workplaces and interfering with their ability to make a living for themselves. But when it happens to you, maybe it's not as fun, maybe it's not as fun. Do you like that? That's what I want to know. Do you like that? Because you've been doing that to a lot of other people. And do you think it's fair that it happened to you, dear? Do you regret it? Do you regret it? And what's your scumbag husband up to now? Are you going to visit him in prison? Do you think they'll have conjugal visits? Please give me a call back when you get this and we can chat some more. Bye, girl. Following the phone call at the 108 mark, Kearney accessed the social media accounts of the company that Elizabeth worked for and laughed as he stated the pages were taken down and stated the TurtleBoy effect. Oh God. Both Mike and Elizabeth Proctor stated they felt harassed by the acts of Kearney. On Monday, September 25th, 2023, at 6:26 p.m., a Facebook account believed to be used by Kearney, which is Clarence Woods Emerson, is the name, posted the following message. Anyone in Canton want to take a couple of pictures for me? DM me, please. At 6:53 p.m., the Facebook post was edited with the phrase, update all set, thanks. On September 25th, 2023, at 8:04 p.m., an X account, formerly Twitter, associated with Kearney, posted this message and photograph. The poster depicts the front of 6 Wentworth Road in Canton, home of Michael and Elizabeth Proctor. The white Jeep Wrangler in the photo belongs to Jennifer McCabe. And there are photographs that are appended to this report I'm reading from, Judge. The following day, Kearney broadcast a YouTube video, episode 617. At the 19-minute mark, Kearney stated that he ran the plates of the vehicle depicted in the photograph. Kearney showed photographs of 3 vehicles parked at the address. He showed photographs of each vehicle and stated the registered owners of the vehicles by name, Michael Proctor and Elizabeth Proctor. The term ran in regard to a motor vehicle registration is commonly used in law enforcement. The term means the information was queried through law enforcement database for the purpose of obtaining information. Kearney used the information in a blog entitled Canton Cover-Up Part 161. Jen McCabe was seen at the Proctor's house at 6 p.m. tonight, despite allegedly not knowing them personally. I would parenthetically state, Judge, that it was later determined through an investigation by state police that a dispatcher in the local police department made contact with Kearney and unlawfully and illegally accessed the Registry of Motor Vehicles database to provide him with information he was not entitled to. Information maintained by the Registry of Motor Vehicles is accessible to law enforcement through the Criminal Justice Information Service. Authorized individuals have personalized access to the CJIS logins and accounts. Recertification standards, which include lessons and tests, continuously assert that CJIS users are trained to the standards and do not disseminate protected private information unless for a legitimate law enforcement purpose, as described in Massachusetts Code of Regulations 803 CMR 7.09. On Tuesday, September 26, 2023, Lieutenant John Fanning of the Massachusetts State Police conducted a CJIS audit to determine if any CJIS user queried the following: Massachusetts registrations. I will omit the registrations at this point, Judge, but one is for Matthew McCabe's vehicle, who is Jennifer McCabe's husband. Another is for Michael Proctor's vehicle. Another one for Elizabeth Proctor's vehicle. The audit produced results indicating that all 3 vehicles were queried by, I'll leave the individual's name out, a dispatcher in the local police department, saved JIS account at 6:22:19 p.m., 7:05:43 p.m., and 7:10:44 p.m. respectively. This individual is employed as a civilian dispatcher. On Wednesday, September 22nd, 2023, Lieutenant Fanning and Sergeant Yuri Buchanek interviewed Webb at the Avon Police Department. Individual stated she'd been employed for a period of 3 years, and goes on to indicate that the query was made at the defendant's request. I'll skip some of this, Judge. The dispatcher provided her cell phone to investigators. Investigators observed communication between the dispatcher and Clarence Wood Emerson, the pseudonym used by the defendant, on Facebook Messenger on the cell phone on September 25th at 6:18 p.m. Dispatcher sends the message, "What you got? I'm here till 8 a.m. Clarence responds, "Sorry, H500," which was a registration. After several messages back and forth, the dispatcher sends the message, "Matt McCabe," to which Clarence responds, "Got him. It's parked at Michael Proctor's house as we speak. Thanks, this is huge." Dispatcher responds with a message again, "Please keep me private. I don't anticipate fucking up in life and never want the wrath of you." At 7 p.m., Clarence sends the message, "Of course. Any chance you could run 2 more? Dispatcher, "Sure." Clarence sends pictures of 2 vehicles parked in the driveway at Wentworth Road. The dispatcher sent Clarence 80 blank numbers Proctor. Clarence then asked about another registration. "Is that Lizzie?" To which the dispatcher replied, "Yes, Lizzie, Elizabeth Proctor." Dispatcher said she has read TurtleBoy blog posts in the past and has followed his media regarding Karen Reed closely. A check of Webb's Facebook page information publicly available relieves she is friends with Clarence Woods Emerson. Dispatcher has posted numerous posts and comments on content on Facebook supporting Karen Reed's innocence and copying Kearney's claim of police cover-up. On a YouTube video posted on October 2nd, 2023, Kearney acknowledged it is illegal to obtain information about the registered owner of a motor vehicle and discussed why it should be legal. I interviewed Jennifer McCabe regarding the incident. She stated she had never met Elizabeth Proctor or Michael Proctor prior to September 2023. Since the first meeting several weeks ago, Jennifer and Elizabeth have communicated regarding the constant harassment, intimidation, and public attacks. Jennifer stated they bonded over sharing the ongoing experience. She traveled to Elizabeth's home to discuss the harassment they had both been subjected to. Based upon the foregoing facts, it's probable that Hayden Kearney committed the violation of Massachusetts general laws, which is Section 13B, witness interference, intimidation of a witness, Michael Proctor and Elizabeth Proctor, and the statute, the pertinent parts read, "Whoever willfully, either directly or indirectly, threatens, attempts, or causes physical, emotional, or economic injury or property damage to, conveys a gift, offer, or promise of anything of value, or misleads, intimidates, or harasses another person who is a witness or potential witness, person who is or was aware of information, records, documents, or objects that relate to a violation of a criminal law or a violation of conditions of probation, parole, bail, or other court order, a judge, juror, grand juror, attorney, victim witness advocate, police officer, correction officer, federal agent, investigator, clerk, court officer, court reporter, court interpreter, probation officer, or parole officer, or D, a person who is or was attending, or a person who has made known an intention to attend a proceeding described in this section, or a family member of a person described in this section, with the intent to, or with reckless disregard for the fact that it may impede, obstruct, delay, prevent, or otherwise interfere with a criminal investigation at any stage, a grand jury proceeding, a dangerousness hearing, a motion hearing, a trial, or other criminal proceeding of any type, or a parole hearing, parole violation proceeding, or probation violation proceeding, or administrative hearing, or a probate or family court proceeding, juvenile proceeding, housing proceeding, land proceeding, clerk's hearing, court order, mediation, or any other civil proceeding of any type, or punish, harm, or otherwise retaliate in any way against such person described in this action for such person or such person's family members' participation in any of the proceedings described in this section, and it goes on to state the penalties for that offense. Based upon the foregoing facts, the Commonwealth believes it will establish a trial that Aidan Kearney committed the violation of Massachusetts General Laws, Chapter 274, Section 7, conspiracy to commit intimidation of a witness by entering into an agreement with the dispatcher named earlier to obtain sensitive information to be used in blog posts and videos intended to harass, intimidate, and cause emotional harm. And given the continuing harassment of witnesses for the murder of John O'Keefe, we believe that the defendant will be found guilty at time of trial should this matter go to trial. That, Judge, that recitation deals initially with Elizabeth Proctor, the wife of Trooper Proctor. Now, there are an additional 8 complaints that I have here, Judge. Much of the verbiage is that's recited is also recited in these complaints, as they obviously have to independently stand on their own. However, for purposes of this arraignment, I can skip forward, Judge, and go to just the pertinent sections for the individual victims / witnesses, because they are both in this matter. For Juliana Nagel, on Saturday, July 22nd, at approximately 1200 hours, Kearney departed Shaw's 134 Nathan Street in Norwood, accompanied by a number of motor vehicles for something publicized as a rolling road rally. Kearney began a YouTube live video. The YouTube Live allows users to broadcast live videos on the YouTube platform, which can be later saved and distributed on a user's account. At the beginning of the video, Kearney is operating a motor vehicle and stated at least 100, 200 people are in the caravan of vehicles. He further stated that he did not broadcast the locations of the protests prior to the departure of the rolling rally. During the video, he stated, this defendant, stated the purpose of the rally is to protest the murder cover-up and framing of an innocent woman. He stated some witnesses will be in jail within a year and brags about being to locate witnesses wherever they travel. During the duration of the rally, he thanked other members of for attending the rally. Juliana Nagel, 25 years old, lives, I'll omit her address, in Canton with her 2 parents and 2 siblings. Juliana was home with her mother at the time of the protest. Juliana and her brother were present at 34 Fairview Road and had been interviewed by investigators. When Kearney arrived at 79 Highland Street, he identified the residence as her home. Kearney made a statement to get the attention of her neighbors. He described how O'Keefe was beaten to death at a house where Juliana was present. He stated, at any point, Julie Nagel, you can come out at any point. Nothing is stopping you from telling the truth. You know what happened that night. He continued to state, you can't get away with it anymore. Too many people know. You're going down with them. Nothing is stopping you from coming forward and telling the police what happened. Kearney claims Nagel lied to investigators about her observations the night of O'Keefe was killed and is complicit in the cover-up of a murder. Kearney stated, you might as well tell the truth and let the world know what happened. Neighbors, maybe you guys can help us pressure them into this. Julie Nagel was involved with, was at the murder of a Boston police officer. She knows what happened and she is actively involved in the cover-up. She should not be able to walk around town like none of this happened while an innocent woman named Karen Reed suffers the consequences of her silence and her complicity. The truth will set you free. Kearney is in front of the residents for approximately 10 minutes. At the conclusion of the speech, he stated the next location is the home of a Canton Police Department Deputy Chief, Thomas Kelleher. While traveling to the next location, Kearney stated Julie Nagel's house was a good one. They were home. And clearly, the statements he made there, Judge, is about as far as he can go to intimidating a witness as to what his intent was. During a recorded interview on the YouTube account, WristFlex, dated August 20, 2023, the defendant made comments about his influence on the jury pool. I want the world to know what happened here. They want the story to be silent, nobody knows about it. They want to be able to find a jury pool that has never heard any of this shit before they can manipulate them the way they have manipulated everyone else, and I'm not allowing it. Not allowing them to do that. Happy to do it. Elite mass corruption, TurtleBoy, 104 mark. Based on the foregoing facts that I've read, Judge, it's clear that the defendant committed a violation of Chapter 268, Section 13B, which is intimidation of a witness and witness interference with Juliana Nagel. I will not recite the paragraph that I recited earlier as to what the language of the statute is. And for this reason, Judge, on the second complaint, docket 1151, we're going to be requesting those same conditions of release. Does I have about perhaps another hour going, or Your Honor wants to take a break, or keep going, whichever Your Honor indicates?
Well, let me ask you this, the issue is bail and release conditions.
Yes, Your Honor.
So, I mean, haven't you covered that?
Well,
Why
there-
I should put a bail on and certain release conditions?
There are, Judge. There are other witnesses, so I would ask that those conditions apply to each of the docket numbers. The facts are fairly similar, but as there are different witness/victims in these cases, the specific facts vary. But they're generally the same content as
I understand, but
as the
the
two I read.
complaints issued, which means that the clerk magistrate found probable cause to issue the complaints. So that's been established.
Correct.
And, I mean, if the alleged victims in the various cases were to be named, then we would, to the extent that I allow any or all of your proposed conditions, it would encompass those people, wouldn't it?
It would, Judge.
Yeah.
So I would ask Your Honor to adopt the Commonwealth's recommendation as to the conditions.
Yeah. All right. Attorney Reynolds, if you
Yes.
could go to the microphone, then perhaps Attorney Novak could slide over a little bit and tell me what is your position with regard to the Commonwealth's request for cash bail in the amount of $1,000 and the various conditions?
Yes, Your Honor. As far as the bail, we're asking for release on personal. He has no record. He lives with his family in Holden, and he has 2 children that he supports. And what we're providing here is that we don't believe that because of his record or because of his commitments that he would be in danger of flight or creating a problem in terms of needing bail. As far as the conditions go, my client states that he is a news person who is using his First Amendment rights to cover a story. Now, I know that he has been mentioning YouTube and social network, but there are a lot of people who do this. And he is requesting that he still be able to do this news coverage. He vehemently denies that he's intimidating or harassing anyone, that the trooper involved is a public figure, that there is a potential selectman involved, that he goes to meetings, and he feels as if that he should be allowed under his First Amendment right to pursue his story. Now, as we go through it in terms of the threats, I just would like to point out that when I read the statements that the prosecutor stated, I see opinion. I don't see threats under the way my client is acting. I said from the beginning, I don't want to go to trial. Most people don't want to go to trial. That's an opinion. That's not
He
perceived.
said he didn't want the Karen Reed case to go to trial.
Okay. But still, it's an opinion, and he put it out on the web. It's really important for the people in Norfolk to know about this story because the jury pool is chosen from there. Again, opinion. Again, the internet allows for that. I'm sure that, or I would hope, that if any of these statements would have violated YouTube policy, They could have contacted that and had it all taken down. In addition, I would provide that this is a lot of reports, and for some of these conditions to apply, such as controlling his followers, not sure how he would do that. I would believe that if he were allowed to continue to pursue the story with his bail warnings, that the police could access or take a look at further events that he does. Meaning that if he calls for one of these rolling rallies, someone will give a call, they can go out and they can determine whether or not it's intimidating or if there's a charge that applies. I mean, that's what I'm arguing, to allow the First Amendment to go forward and to allow the prosecution to continue to monitor the situation. They have police involved, and then each event that comes out of it is under bail warrants. If he does something wrong, he's not free. And that would be my argument.
All right, thank you. Attorney Mello, if you would, for the court and police department, would you identify the alleged victims in the various complaints by name? I think I have them all, but I want to make sure.
I will, Your Honor. In the first instance, it is Juliana Albert. In the second instance, Judge, it is Christopher Albert. And these are in addition to the ones I've already identified, Judge. In the next instance, Judge, it is Michael Proctor. Then we have Colin Albert. This, the intimidation of a witness with a co-conspirator there were two victims in that matter, Judge. Jennifer McCabe and Elizabeth Proctor. Those were incidents where the vehicle registration was run. We have Jennifer McCabe. We have Matthew McCabe, and that is the remainder of the complaints so far, Judge.
Okay. That is a list, if you will, of the alleged victims in the case as to which you're seeking specific conditions. Correct?
Yes, Your Honor.
All right, thank you. All right, in my view, given the individual's lack of criminal record, I don't, it's not a cash bail case. I'm releasing him on personal recognizance. Also, I don't see it as a GPS case. I am not imposing a GPS. What I am doing is imposing the following conditions. Stay away, no contact from each of the named witnesses that were just listed by Attorney Mello and captured by the court and the probation department. Stay away, no contact. That means direct or indirect, including but not limited to mail, email, text, telephone, social media, or any via any other mechanism, if you will, direct or indirect from all of the named alleged victims. Mr. Reynolds, I'm sure you'll advise your client that that is broad, and that is broad, from my view, on purpose. And if it comes before me or any judge, and a judge would find that he violated a release condition, he is subject to incarceration for up to 90 days without bail.
Thank you, Your Honor.
We need a date.
12-5.
Did you coordinated that?
That's-
Mr. Mello,
that's-
what's the comments? That's a little far out. What-
We'll find this fine, Judge.
It's fine, okay.
Thank you, Your Honor.
We've been listening inside Stoughton Court, the hearing of online blogger Aidan Kearney, who goes by the name TurtleBoy, who is wearing a Free Karen Reed shirt in the courtroom, facing 9 charges, mostly witness intimidation. Now, he has accused police of a cover-up in the case against Karen Reed, who is accused in the murder of Boston police officer John O'Keefe. The judge just ruled in the case he can be released on personal recognizance. He was cautioned by the judge that he is not allowed to have any contact, direct or indirect, with the people named by the prosecutor as charging him with witness intimidation. Various instances were read out of him either talking to, calling, or approaching witnesses involved in the Karen Reed case, which he says he is covering as a journalist online and on YouTube. The judge said that he did not have to have a GPS bracelet. He's been released on personal recognizance, no bail, but he has been cautioned not to contact any of the people named in the courtroom today. We'll have much more coming up as we continue our news coverage on CBS News Boston.
For my best skin, it's Olay, because my skin needs more than a basic moisture.
Okay, so he's free, or he will be in a minute, which clearly that was going to happen. Your question, sorry, I ran up the stairs. Woo. What's your question? I don't know. I scroll way back up to find it. I don't see your question. I don't know what it is. Is she asking if it's, what's his face? No bracelet, no bail. Yep, no nothing. Which is great. You could hear all of his supporters outside. Okay, let's address the questions that were in the chat before we get back to the Karen Reed videos, okay? Number one, he's not a YouTuber. He's not in this community. Whatever these rules are that have been made up in this specific community by people are not rules that everybody has to live by just because they dip their toe into our community by being on the Glarers. Life doesn't work that way. So he doesn't have to follow our rules, period. He doesn't even follow rules at all, okay? He has been around. I can't stress this enough. He is not a true crime YouTuber. That's not what he does. His issue is in his community, his physical community where he walks the streets. He goes after, I'll tell you what he did to my really good friend's daughter. And it was awful. It was awful. But what she did was awful as well. So can I blame him for it? No. She was a kid, really bad ADHD, really bad, her mental status was not good. She ended up on drugs, and her new boyfriend, who he had a extensive criminal record, went into an apartment building, into the lobby, and there was a very elderly woman there. They went to steal her purse, and they knocked her down. He heard about the woman and began to report on it. Her pictures, her custody case, everything. You name it, he fucking put it out there. Okay? So people say, well, that's doxing. Well, no, because they were arrested for what they did. So it wasn't doxing. Everybody knew her name because it was in the paper because she was arrested. He dug deeper to say, this piece of shit did this to a 92-year-old woman. And we will not have that in our community. We will not. So those are the types of things that he does in his community, in his town, in his state. It doesn't mean I agree with every single thing that he does. No. But he isn't one of us. Okay? So for me, it's the ones calling out fanboying over Turtle. I can understand what you're saying, Granny. I've known of Turtle, like I said, for 20 some odd years, or however the fuck long it's been that he's been doing what he does. We all kind of hated him at first. Like, He did like Barstool Sports type content, right? And it was aggravating because not every one of my friends are good people. A lot of them were addicts. A lot of them, you know, they deserved what he did to them, sadly. They did, because they were out there doing the things that they should not have been fucking doing. And he's like the reporter of the area. You do something stupid, he about to be on your ass. And that's it. So you can ignore him or not. But here's the issue that I have. Here's my issue. Is he doesn't cover true crime cases, right? He's a blogger who does blogging. And now he's going live and he's talking a lot about the Karen Reed case because it's in his backyard, right? And it involves Boston cops. That's another major thing that he's talking about. So is he a JLR who jumps on every single true crime case and doxes everybody in it and runs around and does all the things? No, right? He did, Kristen, yes. He did a lot of there's a lot of crazy shit that he's done out there. But I don't want people to be confused about what he is, okay? He's not one of us in this community. He's not going to abide by our rules. He would laugh in your face and be like, I don't know who you are, why you made the rules, or what you're doing, but take your rules back to where the fuck they belong in your YouTube community. I'm living my real life out here, and I'm in my own neighborhood doing what I do. He doesn't give a fuck about our opinion. I can assure you of that. So when people are like, yeah, but our community, he's not in our community. I don't know how many times I can say he's not even in our community. He's not going to abide by any of this stuff. Okay. And just because I've known of him for so many years, and, you know, I kind of like the no bullshit approach, right? Some do really respect him, Nunya. Yeah. Some don't. Like, does my friend Bill? No, because he put his daughter all over his blog. But is everything that he said about his daughter true? Yeah. Did his daughter help her boyfriend rob a 92-year-old? Yes. Those things are true. As much as they suck, I mean, they're true. What can you really... You want to be mad at him, but at the same time, if it's fucking true, it's true, right? So there's not a lot you can say, except this sucks, you know? Like, he has Hood Rat Heroes, or one of his things. He does a lot of crazy shit, okay? He posts a lot of crazy shit. I'm not saying everything that he does is right, but back in, like, I don't think he's covered this kind of stuff for a long time, the Hood Rat stuff, but maybe he has. Let me see. What the hell is this? The Methadone Mile, so Boston, gets Ratchet as a junkie, smashes a man's car window. Okay. So there's just crazy shit that people will send to him. It's not like he's there out on, you know, Methadone Mile, which is an actual place in Boston. But people will send it. So, respected Chicopee woman arrested for leading Ludlow police on a highway chase. He wrote about that. It illustrates the need for mental awareness. We could be laying off 600 state troopers in the name of public health. This was back in 2021. He wrote about this. He wrote about masks. He writes about our governor, or their governor, whatever, Charlie Baker. He writes about a lot of shit. A whole lot. If what he's doing is presenting facts, I don't know, maybe I'm missing something. Facts are facts, and sometimes they're really ugly. Yeah. I mean, when he presented the facts on Kayla, I was hurt. I was really sad. Like, this fucking piece of shit. Like, how fucking dare he? And then, you know, I called Bill and I'm like, what the fuck did Kayla do? And he's like, yeah, she did it. She's on video. I don't know. I don't know why he went to the kids' games. His whole thing is like intimidation. Like, if I can't get you, I'm going to make you, like, if you're hiding, I'm going to push until you come out. Angela. I bet y'all do. I loved Baker. I thought he was a good dude. I miss Menino too, though. So there's, I don't know, but what you guys have now instead of Menino. Shit. Yeah, he reports on Monica Cannon Grant accused of stealing over $40,000 in donated money by former Violence in Boston employee. Like, he reports on a lot of shit. A lot of different stuff he talks about. He talked about somebody stabbed in Worcester. He shows the video. A con artist, ex-con, uses 9-year-old daughter for clout to scam people after going to jail for securities fraud. Like, there's just a ton of shit that he talks about on here. I don't know. It's just, you all miss Menino. Everybody misses Menino. Yeah. Yeah. But I think that he expected this. He knew you cannot go to elected officials' events and attack. You can't do that. He knew what was going to happen, right? He knew. This is not, he's not new to any of this. Mumbles, I know. Mumbles Menino. I wrote to him a few weeks ago, and he was going to come up on the panel, and I'm like, you know what? I haven't even had time to dig into any of this. And then Glera reached out, and he ended up going on. It was a great interview. He is, if you think that some of the people on here are bold and forward, he's a whole nother level of that. Like, he has no problem saying that one of the guys in this case is just a big old fat pussy boy who, it's how he talks. He says what he means what he says. It's a little refreshing. Sometimes you are sick and fucking tired of people who are always trying to be politically correct. And it takes them 84 hours to get to the story because they're trying to think of the right words to say. It's annoying, right? He's just going to say what the fuck he says. Period. Yes, I get it. I don't agree with showing up to people's homes. I don't agree with making stuff up in your mind, right? I don't agree with people showing up to the Wells house, right? Nobody died on the Wells lawn. None of that happened, right? But people still try and sneak up their hill and intimidate them and attack them, right? For what, right? Well, the law decides, 9th Live, what's true wrong. So this is the new model for community service when crime happens. Terrorizing witnesses, kids, others in the community, taking justice past punishment we mandate by law. Who decides what's too far? The police, as they did today, right? So they decide. They decide. We don't decide. He's not even in our community. Exactly, Granny's watching. This community seems to think their way is the only way. It isn't. I'm not from this community. I'm not from this community. I'm from a community that Country's also from, that others here are also from, where it got rough and you say what the fuck you say. There was no political correctness. Correct me if I am wrong, Country. But there wasn't. We weren't worried about every single word that we said all the time because somebody might twist it into a narrative that they want. It wasn't like that. You just kind of said what the fuck you said. And you dealt with the repercussions. And I think, and Trish was there too. And she knows too. It wasn't like this. It wasn't like this. There's Ashley, same community. And she's from Boston. She knows about the police there. And it's hard to explain it because in this community, I've had to change my viewpoints on a lot of things because people like Betty, JLR, Molly, they go after people with zero facts. There are zero facts in the Wells case. Zero. None. There are none. In this case, TurtleBoy has pulled every document, every single document. He's outlined them, he's documented them, and he's looked into them, right? So he's saying, based off what I'm seeing here, this doesn't fucking sound right. And now they got this woman in court for murder? I'm behind him on it. I am with him on this. Now, are some of his tactics fucked up? Sure. Not everything is either I love you or I hate you. It's, yeah, I support you digging into this. I support you in the cops' faces. I absolutely support you calling out corruption. 1,000,000%. Do I support you going after kids? No, I don't. Yeah. Exactly. Exactly. Drop would. So Drop was like one of the guys in our community. And a lot of time there would be a lot of fuck shit. And somebody would just kick up alive. Like, we're not doing it. We're not. I recently unsubscribed from many creators who do exactly what you're talking about. Not a fan of people dragging people for money. But here's the thing, Angela, right? We've got her. I don't know how else to say what I'm trying to say here. He isn't going live to drag people for money. He used to be a teacher. He's a blogger, right? He started digging into this case because of police corruption. Yes, he's on YouTube. No, he's not part of our community, right? And we use these terms, dragging, tragedy pimps, this and that. He would look at us like we're aliens. Like, you got to understand, we've made this shit up in this community. And somehow there are people in this community who think that they run it and make rules. And we're not allowed to go outside of the rules or they're going to come at us. No. I live by my rules and my life, and that's it. No, witness intimidation's not okay, right? But at the same time, everything he's done is on film. Yes, he went to the pizza place. Yes, he stood outside with a sign about this big and was laughing the whole time and calling people, saying that they covered up and they murdered and they did this and they did that. And it was broad daylight. There were people there, and the teenage kid who works there come running out. Fuck you, TurtleBoy. I mean, how is he intimidating him? What is he, fucking Whitey Bulger? Like, oh, I'm gonna kill you and your fucking family if you got... No, that's not the same as stalking people like the Wells, following them, taking pictures of them. Candace can't even go to the fucking dollar store without being called a child killer. Do you see what I mean? It's very different. Look what they did outside the Simon house. They played babies screaming, knowing Quentin Simon was dead. This is a very different thing. We can't put everything in one pot because it fits what we want to talk about. There are very different things, period. You're running to Google Whitey Bulger. Are you kidding me right now? It's Whitey Bulger. TurtleBoy, we're about to play you, bruh. If you live. Where you at, though? Where you at, though? I don't see him live. What are you talking about? He's not live right now. You don't know who Whitey Bulger is? Yes, he's live. Where? TurtleBoy. TurtleBoy. Which one of his channels? He's not live. He's not live on my fucking thing here. Not live. No. He's not. He's still gonna get released and all of that. He's not, right? No. The other girl is? Who's the other girl? Who's that? I don't know. It's very interesting to me because I know for a fact I will hear on other creators' live streams today. I thought Chasing didn't support this. I thought he's not in our community. He doesn't have to live by our rules. Okay? Yes, Whitey Bulger was my pen pal. Yeah. Yes. Turtle. Exactly. It's a whole different thing. TurtleBoy's not coming. Like, when he was live, he collected money for Karen Reed's defense as well. Yeah. It's a whole different thing. And he's never going to be in our community. Like, he'd be like, the fuck? I would too, with a camera. I mean, sure, Ninth, if you think so. I mean, it's all good. I'm cool. Think what you want. Think what you want. But when there are police, exactly, when there are police in Karen Reed's hearing, shoulder to shoulder, to intimidate her, and all it takes is one TurtleBoy to go in and sit in there, and an army shows up, like, nah, you're not doing this to her. You're not. And then he's the one arrested on intimidation against what? The fucking Massachusetts State Police and Boston cop gang units? Get out of here with that. He's so intimidated. Oh my God. These are well-known families. Don't get it twisted. This isn't Jack and Jill from over in fucking Dorchester. These are well-known, well-connected families who have a lot of pull. And he's taking them on alone. Alone. Oh. Oh, Angela, I need to know. Just say the last name, will you? My friend used to date Stevie Flemmy, the rifleman. Yes, Whitey's OG. He's not a very good man, but it is what it is. Twisted Tragedies. I don't know who that is, but okay. Let me see. I don't want to play somebody else's shit, but
So guys, they took my phones and my computer. If you guys want to help the cause, again,
Of course.
feel free to donate. I'll be on there. They're trying exact arguments, and they're seeing me now. I don't know how many problems.
Absurd.
I'm exposed.
He told to leave. Crusty Panties came on after she was already told to leave, you guys. She was already told to leave and she's with them. Like, okay, cool. You already did.
I'm exposing what really happened to John O'Keefe and the powerful who murdered him and cover up his murder. And this is what the state does to you when you do that. But several months from now, it will not be me standing on these courthouse steps. It will be the so-called victims. That's who will be here. Because ultimately justice will prevail and truth will prevail, and they will never shut me up. They will never, ever, ever $5 million off of this. What an absurd.
So absurd.
I wish. No, I have not made $5 million.
Absurd.
How much have you made? I have no idea how much you made. How much you made? How much you made? I'm a reporter too. How much you made?
Right?
Yeah, I don't know. I don't know.
Yeah. Didn't count.
What's up?
You were the one who were arrested.
I was arrested for making money?
No.
No, you don't know. Next.
you're not going to win with him. You're not. You see how they try to do him? Did you make $5 million? No, I'm a reporter. You're a reporter. How much you make? How much do you make? They can't win with this guy. You just can't. He's just going to keep going. He's like a little tiny Terminator.
Wrong, Channel 5.
Are you making money up? Are you making money up?
Sure are. probably sure are.
Making money.
He's at the job to do. He has a job to do.
Well, you know what is this mean? Does this mean?
Believe me, I am looking for an aggressive criminal defense lawyer to navigate because now we know that they're going to try to lock me up for telling the truth and exposing corruption. That's what they're going to try to do. So I am going to get an aggressive criminal defense lawyer.
You're gonna beg for the money?
And if anybody's watching right now, I don't know who I'm going to pick yet, but we are going to announce.
No, we'll give it to him. We'll give it to him. Don't you worry. We'll raise it for him.
Reporting the murder. Yes, that was the duty status lawyer, the guy that's in courthouse.
So what that special prosecutor said.
He don't need to beg for money. He's got an army behind him willing to give it to him for nothing.
What do you say to that?
Reporting the news is not harassment.
You hear her? With her thick Boston accent? He don't need to beg for money. He got an army behind him. It was a short summer romance. Angela, where is the name? Reynolds. Do you know the Watts? Ronnie? I bet you know all the guys.
Asking questions is not harassment. You guys all heard what they read out loud today. And by the way, I was arrested by that guy right there, Lieutenant Brian Tully, one of the people I've been exposed. The man who signed all of those fraudulent police reports now exposed for being lies. He had the audacity to come to my house and put me in handcuffs today. I'm not scared of them, and I will not be silenced. Nope. And I will be steadfast in keeping on with his mission to expose the real killers of John O'Keefe.
You're the only one that seems to care.
I have no idea.
Are you going to do anything differently as far as your job?
Everything that you heard in that courtroom today is legal, protected opinion. I would like to point out that 2 weeks ago in this very same courthouse, one of the alleged victims in this matter attempted to get an order in here using those same exact arguments and those same exact quotes. The judge denied it. The judge denied that order in this same exact courthouse 2 weeks ago. So what has changed? What facts of his case have changed? Absolutely nothing. This is a gross exercise of state power. This is what fascism looks like. And as journalists, we should all be concerned that this is what they do. They are also told me that every single person who came to the peaceful protest rolling rally in Canton on July 22nd, one of the things that has led to these charges, every single person in there is now under investigation.
Oh my goodness. Can't gag us all. Can't gag us all.
They cannot arrest us all.
Maybe like coming in today, you mentioned something about a Ford SUV.
Yeah, so a Ford Edge. According to Lucky Lochran, the man who plowed 34 Fairview Road that day, at 2:30 a.m., he drove by Brian Albert's house, and there was no body on the front lawn. He said he would have seen a body had it been there. We know this because he was interviewed by Trooper Yuri Buchanan and one of the alleged victims in this case. According to Mr. Lochran, 30 minutes later at 3 a.m., he noticed that a Ford Edge was parked outside directly where John O'Keefe's body would later be found. 2 months later, here we are. Nothing has been done to find out who was driving the Ford Edge that was parked next to where a dead Boston police officer was found. Nothing. And this is what they're wasting their time with. Me. There is a man who murdered a Boston cop out there, and they're doing nothing about it. And they're coming out to the police actually reporting what happened. And I will not be intimidated. I will not be silenced. And we will continue on our journey for justice for John O'Keefe and for Karen.
You're a freaking straight channel.
You're vicious.
Wow.
Love you guys.
Yes, Aiden. We have a ton of people over here looking for you.
So, guys, they took my phones and my computer.
I figured.
So I got to go get new stuff. but I'll be back. They're not gonna silence me for long. They got that. You know, if you guys want to help the cause, again,
Of course,
feel
of
free to
course.
donate. I'll be on there.
course.
They're trying to silence all of us. They're coming after all of us.
Can't gag us
This is
all.
the most
Can't gag us
I've
all.
ever seen. It's a sign of greatness what they're doing right now. They're scared. They know they're going to jail.
Hello, I'm having a whole fucking conversation. Yeah, so I'm sure they took all his shit because they want to see, was he sending direct threats through text or phone or calling them, or, you know, he'll get them all back, but right now he's got to go get new shit. So that sucks, but he'll be all right. And sorry, yeah, I forget to unmute. We are going to play the court cases, because if you guys haven't seen them, how many of you have seen all the videos of the court case for her? Raise your hand or put a 1 in the chat if you've seen all the videos and you don't even need to see them anymore. The sign language, right? I do talk with my hands a lot. It's fucking crazy. All right, so there's like 2 of you who have seen 3. You've seen all her court cases. Okay. I watch American Senate hearings. They brought Zuckerberg for... Yeah, you can't be censoring people. You cannot. Damn. And you're literally not going to censor him. Oh, it's spam. I love that my phone tells me when it's spam. Kiss my arse. 3, not all. Okay, good. Yeah, talking hands is me. That's me. All right, so we're going to play these. And we'll be chatting as we're playing them, okay? The 2 early one, like 2 of them. All right, so we're going to play them. We're going to play them. So we can all be caught up here. Got it? Got it.
The car door closing, the house door closing while she walked in her high heels on the garage floor. One Meadows is about a mile from the Canton Library. We know the video equipment was working because they have that footage from 12:16 a.m. But in the video that the prosecution turned over to us, there is a gap in that video from 12:37 a.m. to 12:39 a.m., which would have been the precise time my client would have been driving back past the library. We know that that footage would show that my client's taillight was still intact at that point because she never struck John O'Keefe with her vehicle. Yet the prosecution has produced a video from the library with that crucial time period missing. This evidence is strictly in their possession. We've been told that the Canton police provided the evidence to them via a share file, the Canton Library provided this evidence to them via a share file link with a guest ID and a guest password. We need that link, that user ID and that password. We cannot rely on Trooper Michael Proctor, conflicted Michael Proctor, to sanitize exculpatory evidence before sending it to us. We need the original footage. If the Commonwealth answers that that original footage no longer exists, then we'll need an evidentiary hearing to put the relevant parties under oath to find out what happened to it. The bottom line here, Your Honor, is that we've spent 15 months trying to uncover the truth. We are not afraid of whatever evidence is unearthed from whatever source, because for 15 months, every stitch of evidence has been consistent with my client's innocence. However long this case lasts, and I sure hope the prosecution comes to their senses and realizes they have no case because they've charged the wrong person. But however long this case lasts, the remaining evidence will drive a stake through the heart of this prosecution. In the meantime, my client suffers. In the meantime, her life is on hold. while she spends every waking moment defending herself, emotionally, intellectually, and financially. We cannot abide by excuses any longer. We need this court's help. We need you, Your Honor, respectfully, to hold the prosecution's feet to the fire. We need this court to order the Commonwealth to stop trampling on my client's rights to a speedy trial and her right to due process. We need this court to set deadlines for the production of this evidence. Thank you.
Okay, thank you. Mr. Lally?
Yes, Your Honor. So, in response to counsel's motion, just in response to the statement that every piece of evidence that's been provided thus far is inconsistent with the defendant's guilt and consistent with her innocence, I would have a large issue with that. But as it pertains to these particular pieces of evidence, counsel's right in that motions were filed. Counsel's right in that motions were allowed when, as related to inspection of said materials, and the Commonwealth has no issue with inspection of materials once they're back from the lab. Now, the last time we were before this court, back in February, the court had asked myself to reach out to the lab and see if there was anything that could be done to expedite the analysis. I did that, spoke with and filed the necessary paperwork with the lab to expedite as much of the analysis as could be done at that particular time. So at that time, what I was provided with was a deadline of no later than May 5th, that those items, at least as far as the trace analysis and the criminalistics was concerned, would be completed, and I should expect something close to that date. I confirmed with the lab as of yesterday that that timeline is still a viable one. The case is currently in technical review, so once that's completed, then we should have reports that I'm able to provide to counsel. As it pertains to the inspection and the return of the items from the lab to the Commonwealth's, well, at least the District Attorney's Office or the State Police's custody, one of the issues that we've had with that is that in order to facilitate some of the necessary DNA testing, some of that testing would be exhaustive. And in particular, there is a hair sample that was recovered from the rear right quarter panel of the defendant's vehicle. It was taken to the lab, and I was informed by the lab that any testing of that for DNA, for comparative purposes to Mr. O'Keefe, would be exhaustive. So on March 10th, I sent counsel a exhaustive testing form that needed to be filled out, whether or not they want an expert present for that testing or don't want an expert present for testing is really immaterial, but I need some sort of authorization from counsel before the sample is subsumed during the course of testing with the lab. I haven't heard anything back from counsel. I spoke to counsel numerous times. I sent emails, and I heard no response as far as that. So as far as the DNA testing is concerned, the delay on that is because I don't have anything back from counsel as far as whether or not they want an expert present, who that expert is, how to contact them, and how to facilitate the beginning steps of that particular testing. So that is why at least in no small part, why some of the items are still contained at the lab is because the testing is still yet to be completed. But I do hope to have the trace and the criminalistics, and I expect that by next week at the latest. And again, whatever deadlines that the court sees fit to, or deems fit to put on certain things, as far as that's concerned, is certainly within the court's prerogative. I don't think that we need deadlines. I don't think that we need an evidentiary hearing as it relates to it, but that's where it stands. As far as the video is concerned, the video was provided by the IT director for the town of Canton. There was a share file that was shared with the troopers. The troopers, upon receiving that, it was Trooper Dunn who received that video, not Trooper Proctor. If I could just speak briefly as it pertains to Trooper Proctor, there is no conflict. Trooper Proctor is not conflicted in this case. I indicated that specifically in some of the oppositions that were filed to Rule 17. So there's been some photograph taken from a social media site which is purported to be Trooper Proctor with one of the McCabe's children who are a witness in the case. The child that's depicted in that particular photograph is not one of the McCabe's children. The McCabe's have 4 daughters. That's not one of them. It's a relative of Trooper Proctor. It has nothing to do with the McCabe's and nothing to do with this case. Whatever conflict counsel believes Trooper Proctor has just doesn't exist. Now, as far as the video was provided to Trooper Matthew Dunn of the CPAC unit with the District Attorney's Office, that was then shared with Ms. Crawford. It was a person in our office who specifically who deals with forensic and surveillance video and type evidence. It was then archived on our system. Recently, we reached out and spoke to the IT director with the town of Canton again. That share link I tried to send to council, email essentially wouldn't go through. We tried to open it, essentially it won't open. So the link expired within 30 days within 60 days, if not 30 days of it being shared with our office, but the exact information that was provided by the town of Canton was archived by Ms. Crawford, was then provided to council at her arraignment in Superior Court, as well as I was able to download it onto a Citrix file, which I then shared with council earlier this week. So what we have as a video, what exists as a video, what we were given as a video for those relevant time frames was placed onto the archived within our system, was then placed onto a disk, and what's on the disk and what's been provided to council is what we received.
Okay. All right, your next motion?
That would be Mr. Jackson.
Okay.
Good afternoon, Your Honor. May it please the court. We are, as indicated in our papers, we are seeking summonses, and this is dealing with the animal control issue, that Rule 17 motion. We're seeking summonses directed at two entities, the Canton Animal Control and the Canton Town Clerk, both. We believe they both have records. We know they both have records. These are records that we need, the defense needs, to shine a light on Karen Reed's innocence. These are records that are central to our theory of the case, and these are records that we have no other option to get but through a summons. They've indicated to us they have the records, but they need a court order. They need some sort of a summons. Your Honor, in furtherance of this motion, I want to talk for a quick second about a couple of undisputed facts. Undisputed fact number one, on January 29th, 2022, Officer John O'Keefe was found dead in the yard of Brian Albert at his house at 34 Fairview in Canton. That is undisputed fact, where he was found dead and what the circumstances were surrounding that death are why we're here now. Second undisputed fact, when John O'Keefe was found, he had this set of wounds on his right arm. The medical examiner indicated that these wounds were concomitant with his death in terms of the temporal, the time that he died. These were wounds that he suffered at or near the time that he died. And the Commonwealth looks at these wounds and says, there's nothing to see here. Why are we looking at this? This is, you're following a red herring, basically. This is just a road rash. This means nothing. It has no impact on our case one way or the other. This is, according to the Commonwealth, simply a set of injuries that John O'Keefe suffered at the hands of being struck by a moving vehicle. Well, first, I would ask the common sense question, does this look like a road rash? I mean, the court's got years, decades of experience, life experience and legal experience. Of course this doesn't look like a road rash. It's not a road rash that any of us have ever seen. Or does it look more like claw marks and bite marks from an animal, which is exactly what they are? Second, if it was a road rash, where's the rest of the road rash? John O'Keefe had one set of injuries like this. Deep scratches, deep puncture wounds on his arm, on his right arm only, from mid-biceps to mid-forearm and no other place. For instance, mid-biceps and mid-forearm that you might put in front of your face or your body if a large animal was attacking you, resulting in these wounds. Why are the wounds confined just to his right arm? What about all the other pointy bits of a human body if someone is rolled under a car or rolled in gravel because of the car? What about the shoulders? What about the knees? What about the ankles? What about the elbows? None of that exists. These are the only wounds. They're confined to his right arm, and they're deep scratch wounds, puncture wounds that are indicative of claw marks and bite marks from a large animal. And third, what about the Commonwealth's own expert? She has to have opined about this, correct? She has to have said during the grand jury, I mean, this was a full-throated investigation surrounding the potential murder of a police officer. What does the Commonwealth's own expert say? First of all, she was never asked by the Commonwealth during the course of the grand jury about the injuries. It took a grand juror actually asking the question of the witness, and she said, no, I cannot say that is a road rash. There's certainly not enough evidence to suggest that these wounds are consistent with a road rash. Well, she had to have at least talked about the fact that it was an animal, right? She had to. The Commonwealth had to have asked that question. She actually said nothing about whether or not that's consistent with an animal, because the Commonwealth very particularly did not ever pose that question. But we did. We hired one of the preeminent medical examiners in the country, a doctor by the name of Sheridan, Frank Sheridan, and he wasn't some deputy medical examiner. Dr. Frank Sheridan was the medical examiner for San Bernardino County in California, with more than 12,000 autopsies under his belt, the supervising medical examiner for one of the largest counties in California, and he concluded to a scientific certainty that these wounds are from an animal attack. Period. Full stop. So, what do we know about animals and the Alberts? Which is exactly where Officer John O'Keefe was found dead. In February of 2017, we know that the Alberts had a dog. There's a photograph of Brian Albert with a dog, Chloe, in the foreground. By 2019, the Albert family had registered ownership of that German Shepherd. Moving on to 2022, in January of 2022, specifically January 29th, John O'Keefe suffers these animal puncture wounds, these animal scratches, these animal bite marks that are heretofore and up to this date, today, completely unexplained by the Commonwealth. By May of 2022, Karen Reed's defense team starts asking questions about this animal, about these injuries, about the dog, about what dog existed at the Alberts house, where is the dog. We started inquiring pretty significantly. That same month, amazingly, the Alberts informed the Canton Animal Control that the dog was remarkably and mysteriously rehomed. The dog was gotten rid of. And to date, the Commonwealth has yet, as my colleague just mentioned, has yet to release the tissue samples to us for DNA testing to determine if there's evidence in these wounds of a canine attack, which we believe there will be. During that grand jury testimony, Brian Albert admitted to three things. Number one, he admitted that he owned a large German Shepherd. His words, not mine. A large German Shepherd. Number two, he admitted that the dog was at his home on the night John O'Keefe, early morning hours, John O'Keefe was killed on January 29th, 2022. And the dog, according to his own testimony, was inside the house and never in the front yard, which is where John O'Keefe's body was ultimately found. And the third thing that he admitted was that the dog was, quote, not great with strangers, end quote. That's a dog owner's euphemism for the dog bites, the dog attacks, the dog is mean or can be mean. So why wouldn't the Commonwealth ask about these injuries? Why wouldn't the Commonwealth inquire, as we have been inquiring, about the nature of these injuries and their significance in terms of John O'Keefe's death? It's because they know that the answer completely obliterates their case. Their theory of homicide would fold if they got the true answers to these questions. The answer exculpates Karen Reed, and the answer inculpates Brian Albert. That's because if that dog was inside the house that night, not on the front lawn, not in the front yard, but inside the house, and these injuries were suffered or sustained at the time John O'Keefe was killed, then that means John O'Keefe was inside the house when he was killed. And it also means that his body was moved. That's consistent with the facts that we also know to be true, which is not one person that was in that house and ultimately exited that house from that party that night, not one, saw John O'Keefe's body laying in the cold in the front yard. And that's because he wasn't there yet. Multiple people walked out of the house, multiple people who would have no other reason, who would have no reason to lie about that. A 200-pound man, 6'2", lying in the front yard on a light dusting of snow in dark clothing. Not one person saw him. But if John O'Keefe was beaten unconscious in, for instance, the basement of that house, and later moved to the front yard after the guests had left, there's your answer as to why no one saw him. And it also answers two other questions which are looming in this case. Why would Brian Albert rip out the floor of his basement months after John O'Keefe was killed? The second question, why would he sell his house? So in the months following John O'Keefe's death, the dog has been gotten rid of, got rid of the evidence in the basement, got rid of the house, the crime scene itself. Your Honor, I would submit to the court that evidence is literally being destroyed right under our nose. It's been reported that the federal authorities have now gotten involved in the circumstances surrounding this case and have impaneled a federal grand jury to investigate some of these circumstances. But Karen Reed should not have to wait for the feds to figure out which heads should roll. I would implore the court, now is the time for the court to take some action and give us the tools, the defense the tools that we need to fully investigate this case. We need these records to track down this German Shepherd, if it's still alive, which clearly is an open question. Our understanding is, at least up to this point, is that the dog was not only rehomed, but rehomed out of state, out of the jurisdiction of this court and out of the reach of the defense, or at least that was the attempt. We need those records to find where that dog is. If the dog still exists, we need a saliva sample, we need a hair sample, we need something, and then we need the Commonwealth to give us the tissue samples that were taken at the time so that they can be compared. This is vital to the defense. We ask that the summonses at issue for the two entities that we've described, if those summonses issue, our request clearly meets the Lampron standards. Number one, it's relevant evidence. Number two, we definitely need a subpoena or a summons. They will not provide the information without a court order. Number three, this information is necessary for our defense. And number four, contrary to what the Commonwealth constantly says, oh, well, this is just fishing, I think we've established this is not just fishing. We got a fish on the hook. We just need the court to help us reel it in. I will submit on further oral argument regarding the issues or the summonses surrounding the animal control and camp town clerk. If the court has any further questions about those, I'm happy to answer them. If not, I can certainly give the court a preview of the second Rule 17 motion, which deals with the phone records and the actual phone of Brian Albert. But I believe the court has indicated and we've suggested that an evidentiary hearing is in order.
As I understand it, the parties have agreed for an evidentiary hearing, and we rearranged our schedule a bit so that we could accommodate you.
That's perfect.
Okay.
The only thing I would say in furtherance of that, very briefly, is the Commonwealth has suggested that Rule 17 is just sort of a regurgitation of something that we filed back in, I think it was September, that could not be further from the truth. There is new information, there's dozens of pieces of new information that we have.
What I'm going to do because of that, let's let Mr. Lally respond to your remarks on the question first.
Thank you, Your Honor. Your Honor, first I would state it's an interesting sort of straw man argument as far as it being road rash, or that the Commonwealth has always maintained that it's road rash on his arm. No one has ever said that but counsel for the defendant. As far as the injuries are concerned to Mr. O'Keefe's right arm and right forearm, they've always and consistently been described as abrasions caused by blunt force trauma, not road rash. I'm not really sure where the road rash comes from. What I would submit in conjunction with that is, again, divorcing whatever evidence the defendant claims from the context of the rest of the evidence and the rest of the case. It's a little peculiar and conspicuously clear from the defendant's fact section that the damages to the right rear corner panel of the defendant's vehicle, embedded within the bumper to that vehicle, is pieces of cocktail glass. The victim, Mr. O'Keefe, is last observed on surveillance video, external surveillance video from the waterfall establishment that he left just prior to going to 34 Fairview, with a cocktail glass in his right hand. The same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car. As the court is well aware, and I just stated for the record, under Rule 17, the defendant has the burden, or the moving party has the burden to establish that the documents are evidentiary and relevant. Secondly, that they are not otherwise procurable reasonably in advance of trial. Thirdly, that the party cannot properly prepare for trial without such production and inspection. And fourthly, that the application is made in good faith and is not intended as a general fishing expedition. The issue that the Commonwealth takes with the defendant's request as it applies to these particular records is with number 1 and number 4. The Commonwealth would submit that the showing from the defendant is simply insufficient to establish any relevancy or evidentiary value to these records. And then secondly, that this is the very epitome of a fishing expedition. The indication, even from the verbiage that's used by counsel in the motion, sort of sheds light as far as as I just stated, the sort of epitome of a fishing expedition. It's language such as it could shed light, or if true, this fact would undermine the prosecution's entire theory of the case. There have been a couple of theories that are stated within the context of counsel's motion. I can state for the record those are not the Commonwealth's theories. No one ever said that the vehicle struck Mr. O'Keefe in the head and that's what caused the injuries. That's actually not at all what the grand jury testimony or the evidence has shown throughout the course of this investigation and throughout the course of this case. But those could and if true, those very words by definition evince the very nature of this particular request. The first issue would be with the time frame. As it's stated within the motion, it's from 2015 to present. I'm not sure why so expansive a time frame is needed or necessary or relevant to anything that is a subject matter before the court. As counsel suggests, that photographs of Mr. O'Keefe's injuries suggest that he was severely beaten and left for dead, having sustained blunt force injuries to both sides of his face as well as to the back of his head. That there's evidence of defensive wounds. There's a cluster of deep scratches and puncture wounds to his upper arm and forearm. And then the defendant essentially asked the court to take the then inferential leap that these injuries, which are wholly inconsistent with the injuries noted by both the emergency medical personnel at Good Samaritan, where Mr. O'Keefe was taken immediately from the scene where his body was discovered, and from the medical examiner's finding and sworn testimony. So wholly inconsistent with those, that these are, then take the inferential leap that these are consistent with bite marks or scratch marks from an animal, specifically a dog. In support of these assertions, as counsel stated, there's an affidavit from Dr. Frank Sheridan that the injuries are consistent with animal claw or scratch marks. That apparently this doctor looked at and saw things that no one else saw as far as how the medical professionals detail what those injuries are. In those medical records, what the personnel at Good Samaritan, the doctors, the nurses who examined Mr. O'Keefe when he came into their facility, they describe his injuries as a right superior orbital ridge region, approximately 7 millimeter laceration, positive for surrounding soft tissue, swelling and positive breath sounds bilaterally, pulseless, positive superficial abrasions to the right forearm. Dr. Scortibello, the medical examiner in this case who testified at length before the grand jury, described Mr. O'Keefe's right arm injuries as scratches caused by a blunt object. She described or noted that they appeared to be in a linear pattern. She detailed that she observed no signs of an altercation or fight from her thorough internal and external examination of Mr. O'Keefe. And lastly, she testified in great detail as to the swelling of his eyes being related to the fractures in his skull and how those manifested into the observable swelling and discoloration of his face. And essentially what she testified to was that there was a laceration on the right back of Mr. O'Keefe's head, that there was a skull fracture in that immediate area, the right parietal area of the victim's skull. That then caused a swelling on the brain, which she observed, as well as Dr. Stonebridge observed during her neuropathology examination of Mr. O'Keefe's brain post-mortem. That then caused the swelling underneath of the skull, caused the radiating skull fractures that she observed in Mr. O'Keefe's skull throughout, and that the essentially nowhere else for the blood to go, and the looseness of the vascular tissue behind the eye then causes both of the eyes to swell. There was no evidence that Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds. She was specifically asked those questions and testified to that before the grand jury as to those injuries and how they sustained. There's absolutely no evidence that Mr. O'Keefe ever entered the residence at Fairview on that particular evening. Counsel mischaracterizes some other statements made by a witness, Mr. Brian Nagel, who had come to pick up his sister at the residence. She came out, he observed that vehicle. He observes that vehicle from the entirety of the time that he's there. So he's pulling on to Fairview. Ms. Reed is coming on to Fairview in the opposite direction. The right blinker on and a left blinker on. The operator of the vehicle that Mr. Nagel is in then essentially flashes his lights and allows Ms. Reed to pull in first. So Mr. Nagel is there the entire time that Ms. Reed pulls onto the street when she pulls up. Indicates that she initially pulls over to the right-hand side of the curb, then pulls the vehicle forward a little bit further. That's corroborated in testimony from a number of different people who were inside the house, as well as Mr. Nagel's sister, who then came out of the house and talked to her brother at the door of the truck that he was riding. Mr. Nagel further indicated that at no point did the brake lights come off, including the center top light of the SUV that he observed in front of the house. There were no footprints outside of the vehicle. He never saw anyone exit the vehicle. No one in the house reported ever having anyone come inside the house or seeing anyone exit the vehicle. And I'm a little confused just as far as counsel's statements, as far as the multiple people saw Mr. O'Keefe or never saw Mr. O'Keefe come into the house. Or if he comes into the house and he's attacked by the dog, I'm just a little confused as far as are they in the conspiracy, or are these people sort of let out of the conspiracy because they say something that doesn't further that conspiracy? If they're all in the house, and Mr. O'Keefe comes in the house and gets attacked by a dog and then gets dragged out to the bottom of the lawn and left there for dead, then why do they all testify that no one came into the house? It's consistent throughout the entirety of all the witnesses. It's consistent with Mr. Nagel as well. It's consistent with the forensic evidence. It's consistent with every piece of evidence that has come to light at this point. And there's further statements in regard to the dog. Some reported incidents several months after the death of Mr. O'Keefe. The counsel suggests ineluctably that the animal was violent and prone to violence from one incident that postdates this particular time frame of Mr. O'Keefe's death, and seems to punctuate that this circumspection on and on about how violent the dog is from an incident that he has no information about, whether or not it involved another animal, whether or not it involved another human, whether or not it involved what exactly the incident occurred. This is simply not what Rule 17 is to be used for. That's what the case law has consistently held, is that it is not a discovery tool. It is based on information, relevant evidentiary support, which is completely and utterly lacking in this particular motion, in this particular submission. So for those reasons, the Commonwealth would request that the motion be denied.
Okay. So the second Rule 17 motion, are we going forward on that and then having the hearing regarding the timing of the video? How are we going forward with this before I hear from you on the substance, Mr. Jackson? What is the next date for?
May 25th.
Right. What's it for? The
to call
evidentiary
those-
hearing?
Yes.
All right. So do you plan on arguing your Rule 17 motion today or that day? Not both?
That day.
Okay.
I'd rather reserve and
That
argue
makes sense
the
to
17th that day.
That makes sense to me as well. So we're finished for today, unless there was any follow-up to Mr. Lally. I'm
There
not
is.
going to hear a preview on the motion that we're going to hear on that day.
That's fine. I do have some points to make.
Okay, I'll hear you on that.
Thank you. With regard to the dog, first of all, I think the Commonwealth misses the point. If there was a fight inside the house with the dog's owner, the dog would likely attack. That is the idea that is borne out by the evidence that we have. We know that he was beaten. We've got evidence that John O'Keefe was beaten, that he lay there unconscious. And we also have evidence that at the time he was beaten, facially, and blunt force was used against the back of his head, he was also attacked by an animal. Well, Brian Albert, who's a known fighter, owns a 90-pound German Shepherd that has since been gotten rid of, and had a skin-piercing incident as the excuse for having gotten rid of it. So we know that the dog attacks, according to sort of uncontroverted evidence. We weren't saying, and we don't suggest, that the dog killed John O'Keefe. We're suggesting that the dog was there when John O'Keefe died and also attacked John O'Keefe. That's the point. This is the first I've heard of the Commonwealth's new position after, 15, 16 months, that somehow John O'Keefe was stabbed or cut up with a broken cocktail glass, which would produce these injuries. That makes absolutely no sense. It just doesn't pass the sniff test. These are not from a cocktail glass. Who did that to him? Is there a new theory that Karen Reed got out of the car, broke a cocktail glass, then wielded an edge of that cocktail glass and cut up John's arm? Then John stood there while she jumps in the car, slams it in reverse, then hits him with the car, with her tail light in the back of the head. It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck. This looks like an animal attack because it is an animal attack. And it's at the same time, temporarily at the same time, that he was otherwise beaten and then ultimately left for dead. Interestingly, it's interesting that the Commonwealth doesn't mention the basement in their arguments. I mentioned the basement because that's very likely exactly where John O'Keefe went once he walked into the house. There's no evidence that John O'Keefe walked into the house. The Commonwealth has evidence that John O'Keefe went to the house. They haven't. They just sat on it for several years, or for several months, over a year. That the Apple Health data from John O'Keefe's own phone establishes that once he was at the location at 34 Fairview, he climbed 3 sets of stairs. The Albert house happens to be 3 floors, a basement, a middle floor, and an upstairs. His Apple Health data also shows that he took multiple steps after he left the car, after he left Karen Reed's vehicle. The multiple steps indicate that he was in the house. If, in fact, the Commonwealth were correct, and he stepped out of the car, was hit by the car, and fell down and died, if that's what their theory is, he would have no Apple Health data suggesting that he was climbing stairs and walking about as if he were inside the house and was ushered down to the basement, at which point there was a fight, he was beaten to unconsciousness, and then everybody in the house leaves, not having to go down to the basement. There's a door that services that basement that is closed. So there's no reason for people who are upstairs, either upstairs or on the main floor of the house, to even know that there had been a fight downstairs, or that John O'Keefe never made it out of the house alive or conscious. With regard to Ryan Nagel, the Commonwealth leaves out probably the most important part of his testimony. Ryan Nagel's testimony is that he arrived just after Karen Reed arrived. They arrived not at the exact same time. She turned down the road. Then he turned down the road. As he approached the road, as he approached the house, he then pulls to a stop. He had her car in his sights the entire time, just after she had already arrived. Certainly time enough for John to get out of the car and walk toward the front door. He said that he observed that there was no taillight damage whatsoever. He later observed inside, either through a dome light or through other ambient light, that he could see inside the passenger compartment of her car, and that she sat there alone. And most important, he didn't see her hit anybody with her SUV. That's the most important part of Ryan Nagel's testimony. He didn't see her hit John with the car, which he would have had to have seen if he was situated right behind her. And the Commonwealth has repeated what they've oft repeated several times, which is there was no sign at all of any kind of an altercation or fight. Well, if there's no sign of an altercation or fight, how can you turn around and say that a cocktail glass did this? I mean, they can't talk out of both sides of their mouth. How could they reasonably ignore two black eyes, a laceration over his right eye, a laceration at his nose? He looked like he had gone 10 rounds with Mike Tyson, as my colleague has once analogized. Of course there's evidence that he was in a fight. The back of his hands, deeply bruised. Those are called defensive wounds. I don't care what their medical examiner called it. Anybody who's seen any sort of a fight, a street fight, knows that the back of the hands, the back of the arms, get the brunt of the punches as you cover your face. Of course there were signs of a fight. Not just a fight, a brutal fight. And what does a dog do when its owner is in a fight? What does a German Shepherd do when its owner is in a fight? Reaches out and attacks and supports his owner. And what does a person do when a dog attacks? Usually puts his arm up, his dominant arm up, to protect himself. And that's where the lacerations, the bite marks, the claw marks appear on John O'Keefe's arm. This is not a fishing expedition. The Commonwealth has an unreasonable expectation. They cite to words that we use what the evidence might show, what it could show, what it potentially will show, as a weapon to say, well, see, they don't know what the records are going to show. Well, if I knew what the records are going to show, I already have the records. I wouldn't need the court to ask for them. Of course I don't know everything that's in the records. And the reason that we asked, Your Honor, for 2015 is because we have evidence that in 2017, the dog looked full grown. So we wanted to go back and bracket the proper amount of time. If, say, the dog was a couple of years old at the time that photograph was taken in 2017, we want all the records associated with that dog, which means we bracketed our request. It's not overly burdensome. It's certainly not burdensome to the Canton Animal Control, and it's not burdensome to the Canton Town Clerk. And if the records don't exist, because they just don't, they're too old, then no harm, no foul. But that's why we bracketed our request to go back from 2015 to present. And with that, Your Honor, I believe that we have made a good faith showing. We have met the standards of Lampron, all four standards of Lampron, and the summonses should issue. And also.
All right. Anything else, Mr. Lally?
Just briefly, Your Honor, as it pertains to Commonwealth would agree that attributing the cuts on Mr. O'Keefe's arm in their entirety to cocktail glass would be somewhat ridiculous. That's not what I said, and that's not what I was attributing them to. And I think the court understood that, but just so counsel understands that as well. As it pertains to Mr. Nagel, what is in his testimony is that he had the vehicle, they arrived at the residence in tandem. The vehicle was there when Mr. Nagel left. So while he sees no one exit the vehicle, no one enter the house, and no one else sees anyone exit the vehicle or enter the house during that specific time frame, the defendant, and presumably Mr. O'Keefe, are still there and still in the vehicle at the time Mr. Nagel leaves the house. That was the point that I was making with that. As it pertains to the Apple Health data, and obviously we'll get into this a little bit more when it comes to that subsequent Rule 17 motion, the Apple Health data is the same Apple Health data that's being relied upon for the supposition that Mr. O'Keefe went inside the house. That same Apple Health data has, among other things, Mr. O'Keefe taking 46 steps and traveling a certain bit of distance around 11:56 a.m. on January 29th. The problem with that is that he was pronounced deceased at the Good Samaritan Medical Center at 7:50 a.m., some 4 hours prior to that. In addition to that, from the information as far as when that ascending or descending of stairs occurred between, I believe it's 12:21 and 12:24 a.m., there's a Waze search and location data from Mr. O'Keefe's phone. The Waze search is conducted, and the GPS location information from Mr. O'Keefe's phone shows him en route to the house and not arriving at the house until 12:24 a.m. So the information the council is relying on has him going up and down 3 flights of stairs before he's even at the house. So for those reasons, again, the Commonwealth would submit that the defendant has not met its burden and ask that the motion be denied. Before we do conclude, I just did want to remind the court there are a couple of other issues that I need to address with the court, specifically the Commonwealth's motions to impound and the Commonwealth's motion for access to the defendant's phone.
Okay, I'll hear you.
So there were 2 motions to impound that the Commonwealth had filed. One pertains to the grand jury transcripts and exhibits that I had attached as attachments or exhibits to the opposition to this specific motion, and really to both motions.
And those are impounded by statute.
Right. The other motion to impound that I had filed pertains to the attachments to the defendant's Rule 17 motion pertaining to Mr. Albert's cell phone and the call detail records of Ms. McCabe and Mr. Albert. Now, certainly, the Commonwealth is not saying in any way, shape, or form that those items shouldn't be submitted. The defendant can submit whatever she wants, whatever counsel wants in support of that request for the court to review. But the manner in which the information is released, and specifically what I take issue with, and I'd be remiss if I didn't say this on behalf of the O'Keefe family.
I'm not sure they hear you.
In reference to the motion to impound the attachments to the defendant's Rule 17 motion for Mr. Albert's phone and the call detail records of Mr. Albert and Ms. McCabe, I'd be remiss if I didn't, on behalf of the O'Keefe family, as well as just what the statutory rules are, and specifically I'm talking about the Supreme Judicial Court, Rule 124, pertaining to protection of personal identifying information and publicly accessible court documents, which I would imagine that at least Mr. Munetti, even if Mr. Jackson and Ms. Little aren't familiar with, does provide rules as to how things are filed that are of that kind of sensitive nature and that kind of biographical information. And they're routinely filed with the court with a motion to impound or a motion to seal, and not filed directly with the media. The issue being that there are photographs depicting Mr. O'Keefe post-mortem at the Good Samaritan Medical Center, as well as possibly some autopsy photos that should have been impounded. There are unredacted Canton Police Department reports, multiple copies. Again, not anything that the Commonwealth takes any issue with the court reviewing, but as far as them being made public with those witnesses' names, dates of birth, social security information, addresses, phone numbers, things of the like that should be impounded pursuant to the statute as well. And in particular, I do take issue with that motion, specifically on page 11. There is a specific reference made to the name of the decedent's niece, which is strictly prohibited as far as being provided in a public document. So for those reasons, I would ask that the attachments to that motion, to whatever extent it can be at this point, given the public release of them, be impounded.
Mr. Yannetti?
Your Honor, I believe that some of that information may be in the public domain already, so it may be that the cat is out of the bag with regard to some of it.
It is now, right?
I'm sorry?
It is, the cat's out of the bag now.
Right, yes. So, I mean, we're agnostic on this motion to impound. We have access to it, the Commonwealth has access to it, and most importantly, the court has access to it.
All right, so by statute, everything that was raised by the Commonwealth was supposed to have been requested to be impounded at the time it was filed. So that was not done.
Are you talking about the motion that we filed with regard to the Albert phone motion?
Yes, the attachments. Mr. Lally just outlined it.
I don't think that there were any grand jury minutes attached to that motion.
No, that was a separate motion that Mr. Lally just
Right.
filed on behalf of his motion.
Right, and we don't have
When
any-
he was taking issue with the defendant had filed.
Right. Okay. Yeah, again, we don't have an objection at this point.
All right, Mr. Clerk, those are both allowed. All right, is the hearing, those are both allowed by statute. So is this hearing over?
Your Honor, if I could just address, the Commonwealth had filed some time ago a proposed procedure regarding communications stored in the defendant's iPhone. So we had addressed this briefly, I think, on the last court hearing date in February in relation to the defendant's phone. So the defendant's phone was seized lawfully from her pursuant to a search warrant. The information contained therein was then downloaded. Upon a cursory review of that information, there was an indication that there was some communication between Ms. Reed and Mr. Yannetti contained within the information within that phone. So obviously all examination of Ms. Reed's phone from the Commonwealth's perspective ceased at that time. And we had begun exploring and filing this motion. I had it in hand to file with the court on the last date. However, after several discussions with Mr. Yannetti and counsel for the defendant,
Look at this. You see these? Do these to you look like look at this. Those are dog bites. Those are dog bites. There's no way that they're anything but dog bites. You can see the puncture wounds. I have enough dogs that I know a damn dog bite. There were others. Let me see if I can get a better. No, it's not any better. But I don't know why my phone is stuck like this, but look at this. Look at this. Truck. Car. I hate it. Hold on. Come on, bro. No. Hold on. Look at this. Come on. Won't let me present. You're such a pain in my ass. Stop. Look at this, bro. Black eyes. Huge wound in the back of the head. Bruised hands. Bruised back of the hands. Look at this. There's no way. There's no way. Look at this. Those are from a dog. Well, yeah, it's a big German Shepherd. Let me see. I just showed the dog. Her name's Chloe. You can see her a little bit, but not a lot. They got rid of her out of state. Look at this. Look at his eyes. Bruised, swollen. Colin had bruised knuckles for weeks. It's just crazy to me. Wow. Brian Albert never come outside of the house. He's a cop. He didn't come outside the house. Chloe had to have been barking, allegedly. I wish I had a picture of Chloe, but I'll find one. I'll find one. It's just all crazy. But tomorrow we're going to go over the next court hearing. Okay? Yeah. There's no way. This is insanity. It's insane. What's this? Yeah, they said it was a blizzard. Look at this. It was not a blizzard. We all know what a fucking blizzard is. So they would have seen him. Independent thinker. His actions? Do you mean Aiden? TurtleBoy's actions? I was explaining this earlier, and I will say, is that it? Yeah, I'll tell you one sec. So this is where his body was, right? Right here. You'd easily see him. Easily. It's crazy. It's crazy. Turtle Boys. Okay. So the reason that I am more on the okay side with what he's doing is because of what he believes is happening, right? The corruption of the police force. Not just willy-nilly, not just like us saying Hawkins County is out of control, right? Hawkins County, oh my God. Or saying that the sheriff in Quinton's case, the chief there, was just corrupt. There's no evidence of any of that, right? But the things, let me show you the discovery and the documents here so that you'll see the things that he has, right? So he's going by the information that has been let out, that he's requested. And he's saying none of this based on my history in this state with these people. This does not sound right. So you can see it here. Look at this. Okay? This is a lot that they're using. He's not just watching a crime case on YouTube like many of the people we see here and running in to solve the case and record it and get super chats, right? That's definitely not anything that he's doing. He has been doing this type of thing, but not in like crime cases, but overall in general, in his own community. This caught his attention because this woman is being arrested for killing a cop, right? A Boston cop. And as much as we talk shit about Boston cops when you're from Boston, like, oh, these motherfuckers corrupt, there's a ton who aren't corrupt, right? So we stand by our police and you back the blue, period. But you also know that if one of them gets in trouble, they are going to protect each other like nobody you've ever seen. So when he started looking at all this, his feeling on it was something's very wrong here. So his whole idea is, I'm going to get in their faces. I'm going to get in your face. The cops. Do I agree with him going after, the 17-year-old or the 19-year-old? No. I don't think that's appropriate for him to be doing. But I absolutely believe that calling them out where they stand is appropriate. call them out where they stand, name their names. And like with the Wells case, I'll just keep going back to the Wells case because it's the one we're most all familiar with for the most part right now. TBI put out their information. There's a website on Summer. End of. There is nothing else, right? There's just nothing else. Yet, for 2 years and some months, we've made up complete theories in our minds. There's none of this. There's none of this stuff, right? There's none of this. People who haven't been there, haven't really talked to people, are making up stuff in their mind and harassing, calling jobs, calling family members if they can, doxing people online, attacking people online, saying the most disgusting things about Summer, saying the most disgusting things about the parents. It's very different. What we're talking about here is in real life, he is standing face to face with these guys as they stand in a courtroom to intimidate Karen Reed, which is insane. You typically wouldn't see anything like that. You would not see anything like that. But in this case, you do because they're very loyal to each other. To me, it is very, very different. And I get independent thinker. I totally get why some people would be like, why the fuck would she support TurtleBoy if she doesn't support Betty or Dolly Vision or anybody else who goes real life? Because this is part of his real life, right? This is his community. These are his police. And he feels like somebody out there killed one of our cops. And I think it was another cop. And we're not going to let you hide this. If you put in Boston police corruption, there's a lot. And I'm not saying Boston cops are bad, but I am saying it's a very, very, very well-paid job. And you don't want to lose it. You don't want to lose your job. You got to ask yourself, if we're just thinking critical thinking, why wouldn't the man who owns the house, who is friends with the victim, why didn't he come outside of his house? Just why didn't he come outside his house? It's very strange. You know? Why didn't, there's so many things. Jennifer McCabe deleted a billion things out of her phone. Why? Exactly. He's doing it on fact. Yeah. I'm not even in the US and you've heard about Boston law enforcement corruption. So Jennifer McCabe, they go over who each person is, how they are related to the case. And if you go down here, Jennifer McCabe is Nicole Albert's sister, Brian's sister-in-law. She's the one who Googled how long to die in the cold at 12:27 a.m. and was the first friend of John that Karen called the morning she couldn't find him. Was with Karen and Carrie when they found John and claimed she heard Karen say a bunch of times that she must have hit him. Yeah, she typed it in and deleted it. Absolutely. I may not agree with an action. So far, I've agreed with almost everything that he's done. He crashed one of the elected officials' parties. I'm 100% in support of that. I want them to know it's not going to go away, right? And I think because Boston police and the connections that certain people in this case have, they are very intimidating, very intimidating. And they think you're just going to go away. You're just going to shut the hell up in almost every single situation. They are scary. They're not. Yeah, watch. Speaking of Whitey, watch The Departed. Yeah, watch The Departed. Yeah. And I mean, the Departed movie is really not far off from any of this stuff. Oh, absolutely. Morrissey's a prick too. you know? And that's another thing. Turtle Boy's like a gnat, like a gnat that bites you and then comes back and bites you and won't go away. He will not go away. And he means it. Like he's telling them, I'm not going away. So Angela and other people who are in here are from the Boston area or live in the Boston area. And if you know about Whitey and what went on and how he started out kind of like a Peter Pan guy, you know, and ended up doing some pretty horrific things. It's pretty bad. That was a big part of Boston. Big part. Doesn't he dox and harass people? No, he isn't doxing any. This is all, you can see the documents. This is a case that is very public in Massachusetts right now. You can read it all. These are all affidavits. These are exhibit lists. These are Commonwealth's findings. He's reading them, right? And he's telling you, these are the people who were there in this case. Nobody gave a fuck about this case. Nobody was on the court steps for Karen Reed. Nobody cared. She just went away to prison for murder because nobody was paying attention to it until he came out and said, wait. This is trash. This shouldn't be happening. And I'm glad that he did. So we're thinking docs, right? Like my name on here is Chasing Truth, right? And then somebody doesn't like me and they find out my real name and where I work and they dox me. Okay? If we're talking about Chris Watts, am I doxing him or Shanann or their children when I talk about their case? No. Are we doxing his girlfriend when we talk about her in the case? No. Are we doxing the people in the Delphi case right now who could be Odinites who are not named in the documents? No. We're not. No. That's not what doxing is. I think people need to understand and learn exactly what doxing is. It's keeping your identity private on purpose when you could be put into a public spotlight, like being on YouTube, and you purposely call yourself Gavel Geeks, and somebody purposely digs for your name. Now, if Gavel Geeks is arrested tomorrow, and there's an article in the newspaper, and somebody reads that on YouTube, that is not doxing. No. I learned about Bulger from Detective Maines on his YouTube. Really, Fairy. I used to write with him while he was in prison. He was a sad old man. And I know that people don't like that answer. I get it. But it's the answer I'm going to give you. It's the only answer I have. That's why we have cool names. Public record is not doxing. You have to show intent to malice harm with said information. Absolutely. It is a scare tactic used on social media to intimidate people. That's what it is. That's what it is. This is a whole public case. There you go. So let me see here. Now, daughter of Brian and Nicole, Caitlin, she left 3 minutes before John O'Keefe arrived, right? So that's why her name is mentioned. Dog, whatever. Where's the Colin Albert, son of Chris Albert, nephew of Brian, likes to fight, notorious for not liking John, was definitely inside 34 Fairview. He's part of the case. What can you do? He's part of it. Let me see something here. He's 18. He's an adult. Colin's 18. Oh well. He grown. I do think it started. Absolutely. I think that he got in a fight with one of the Alberts, and unfortunately, he got hurt. The dog jumped in because that's the dog's job, to protect its owners. That's it, right? And then one cop or one couple who are really good friends with another, they're not going to turn in their friends. They're not. It's about intent. Yeah. Yeah. There's going to be a lot. Could you hear them outside of the courtroom today? All the turtles. It was insane. I mean, they were disruptive of the court. They were disruptive of the court. But sometimes, I know this is going to be a very controversial thing. I'll use it in a few different ways. Some of us love Gray Hughes because he says what the fuck he says, right? He just does. He tries not to be too insulting, but he says what the fuck he says. Donald Trump, same. You get tired of people taking a piss on you and telling you it's raining outside when clearly it's not raining. It just isn't raining. And I'm tired. It's piss. That's what it is. So just say what it is. Stop pretending that I'm in a nice rain shower, because I'm not. Right? And he's kind of like that. TurtleBoy's kind of like that. When the news reporters have to be a bit more ethical, and they've got to be, they name names too, but they've got to be neutral, and they can't be as, in your face. Yeah, they have a huge, yeah, absolutely. Absolutely, they do. What do you do when there's so many lies being told about a case? You expose the lies. And that's what I like about him. That's what I mean about the piss and the rain, right? That is what I like about him. It is. Do I appreciate it when some random ass YouTuber jumps into a case, doesn't know the fucking facts of the case, and goes and doxes everybody and their mother, even people who aren't related to the fucking case? No, I don't. I don't support them. And they're gross. Yeah, sick of it. And so that's why I like him. He knows about this case. He can tell you. Half of these YouTubers on here can't. They don't even know what they're talking about. Literally. They could be reading it and still don't know what they're talking about. And it's like, you're just pushing your agenda for how you want it to sound. That doesn't work for me. I want to read all the documents, understand the whole situation, and then talk about it. Not just jump and fucking think I know what I'm saying because I saw an article or heard another YouTuber talking about it. That we see that constantly on here. It's exhausting. So, yeah, when I see them doxing people, it makes me sick. I want to punch them. And it happens too much. Absolutely. Deets. I personally don't like some of the way he's exposing some of these lies, but if I was in Karen's position, I hope someone will go this hard. Absolutely. They are a force to be reckoned with. The judge was asked to step down. She won't. There's a lot of connections here. And you've got to understand that this isn't a family who doesn't know people. It's a very large group. 3 months, and the things people are saying are so wrong. See? And that's what gets frustrating. It gets really frustrating. You're in now, Gavel. You're in now. It's a lot, right? It's a lot. But it's so interesting. really is. All right, so we will meet tomorrow morning and we're going to watch the next 2 court appearances, if that works for you guys, okay? Okay, I love you, but I'm sweating and I have no deodorant on and I stink bad. You know what I'm saying? So I really need to go wash up. Like, I'm gross. I've been running up and down the stairs. It's just disgusting. Well, maybe people can change that, right? All right, I love you. Bye.